casual stenographer engaged in Doordarshan Kendra Bhubaneswar, and since 2002, he was there for on the basis of a contract that she will be given 9 days work in a month, 7 days, 9 days work. Subsequently, it was enhanced to 13, and there was a request to engage them for 19 days. And while they were continuing as such, they made an application for regularization as per the scheme provided by the pursuant to the Honorable Supreme Court direction. The scheme was prepared, and your lordship can return to page 45. Prior to this impugned order, earlier I had approached the tribunal, and tribunal has passed this order at page 45, directing the
to consider.
No, to make a list including our name in the out of scheme basis. There are three. One is a regularly eligible appointment, ineligible candidate, and one is out of scheme candidates. It was not prepared. There is a specific direction to do it. And subsequently, when it was not approached for regularization by way of a representation. And my representation was not considered, for which I approached the again tribunal. Tribunal directed to dispose of my representation. My representation was not considered, for which I approached the tribunal for the third occasion for regularization. My prayer for regularization has been dissolved.
Rejected because it says they do not, admittedly, they do not come, are not coming in the category of eligible and ineligible.
But we are coming under out of scheme. That is third scheme.
That is a separate scheme.
Separate scheme.
Eligible, ineligible,
and out of scheme.
Out of the scheme.
Out of the scheme.
Under the out of the scheme, what is the what is that part? Read the scheme.
Your lordship, scheme I don't have purchased now, but the order of the tribunal is like this. Page 45. The grievance of the applicant in this.
Then only I asked this question.
Yes. Out of eligibility, those who have come back in a backdoor method, but they have the eligibility criteria, those appointment will be, their name will be there. My only endeavor.
The paragraph 4, kindly read. Page 46.
Yes. From the record, we find that working of the applicant on casual basis for some time is not in dispute. Therefore, Mr. Barik, then additional so appearing for the respondent, fairly submitted the name of the applicant on a base in the least third category, which has not inadvertently been done. Then, in view of the above, the respondents are hereby directed to insert the name of the applicants at the suitable place in the third category list prepared and published at Annex 5 series and issue the revised list within period of 60 days from date of receipt of the copy of the OA.
This order you are challenging?
No, I am challenging Annexer 1. This is in my favor. It was not acceded to or it was not worked out. And then I approached under Annexer 1 is the impugned order here, where we claim for regularization of our service. So it is not due to wrong advice that approach. My only endeavor, even though it is not a case of regularization, but my place should not, I should not be in a below stage or in a worsened stage when I approached your lordship or when I approached the authority. In the meantime, what they are doing, they have appointed me, they are allowing me to work through a service provider. That too in a very less amount. Per day we are getting 1200 somewhat. Now it is getting, we are getting 700. When matter was pending before the tribunal for regularization, plus in the verge of the final conclusion of hearing, they reverted me. I mean, they allowed the service provider to give me the, instead of listing my name, they allowed.
Why you want to have a middle agency, middleman?
My lord,
you engage services of the
petition is coming at a daily wage basis or the causal level. Huh? We are neither the petitioner status is neither is a causal level nor as a daily wage basis worker in the
stenogram.
Only we are giving this according to work requirement. Putting a outsource agency. If required, then they will provide it.
Why agency? You give it directly to them. She has been working how long?
Since last 20 years. 22.
There is no sanction for. This is the whole problem.
No. You are engaging the services of the lady through some agency.
We are giving agency, yes.
Remove that agency. Take her directly. Otherwise, part of the money will go to the agency.
So what happening with usual case, Lordship knows, those who are working with the or with the contractor also, they are claiming subsequently.
We will say that we will not regularization. Otherwise, what happens is, through the agency will collect its commission. And it will give only lesser amount to the lady.
Around 40%.
May I pray that my lord?
Yes.
My lord, my what lords, my suggest, ask the officials, if it is possible to adjust something.
Correct. Heard. Admit. The DST is requested to accept notice for all OPs.
All they have appeared in filed counter affidavit.
You opened the counter also?
Yes.
Then we need not make this order.
No, notice was not issued, but when you have listed it with the quoted by. They have told that you file affidavit, then we can.
You also can see the order dated 3920.
Suggestion is coming, then I will.
3925.
Not after 2 weeks. You
Yes.
come out with your version.
Yes.
You put this to your officers.
Yeah.
Right? What are the consequences of removing the agency? All these things are
Yes.
a matter of
Because-
policy.
yes.
Just look into and come back.
Definitely.
Call after 2 weeks. At the request of DST. Okay.
Item 2,
Your Lordship.
2095-2026.
2 weeks.
Just must we have to specify it so that statement is specified.
Very, very bit difficult. If it is not posted after 2 weeks, just move a memo. We remember these things.
So item I am appearing for the opening.
Right?
Second item is the.
You are appearing. No?
Yes. Yes.
Same issue.
Or we can do one thing. We will permit you to make a representation to take your client on direct basis without involving the agency. On that decision, on that representation, decision has to be taken within 4 weeks.
Yes.
With that observation, I do after.
No, you also keep the matter.
No, we will not
because-
keep the matter. Because once we give the direction, we can't keep it. If there is violation, you have to file the.
Admittedly, earlier OA order has not been complied with.
For that, contempt you should go.
No, OA order is under challenge. I have neither they have challenged nor I have challenged.
It has attained finality.
That is finality. So our name has to be included in the third category.
You include in the third category. Why you have not included in the third category? Already there is a decision.
My lord, he also not come to the third category because.
No, you know that you cannot say because there is come to kindly come to case. Come to
Observation of the law and tribunal.
Yes. That has attained finality. To that extent, order of the tribunal has to be modified. What we will do is, you comply with that order which has attained finality. In addition to that, let her give a representation to continue her on an independent basis without a right to seek regularization.
My lord, it is better what suggestion my lord given the first time. This about this asking the officials. If it materialize, authorized not so much. If it materialize in this way, then.
But that was a very innocuous order. And that will not seek regularization also.
Then they recognize.
They will not seek that. And you consider the representation. But that earlier order, you have to do that. In the third, that out of the list, that category, you have to.
Page 46 of this.
That's fine. Right, take down. Petitioners, being the part-timers,
Casual stenographer. Casual stenographer.
are knocking at the doors of this court for assailing, same order,
Annexure 1, same, common order was.
common order.
Yes,
my dear.
common.
For both. The common order, go to that order. Dated
Dated
My lord,
9/7/2025.
9/7/2025, whereby their OA numbers 220, 260,
And 5821. 260.
511 of 2018, 581 of 2018. That is two.
Two numbers.
511 of 2018.
Yes,
And
581 of 2018.
and 511 and 522.
260 stroke 29 is not necessary.
260 we are right.
This is a
Below my,
People see order to put in, that order is going to challenge.
where that
No. That is now impugned order.
So that will be
260 is the code number.
Annexure 1.
Yes, now, cat.
Annexure 1 is that.
Yes.
Annexure
Improved
1.
order is Annexure 1.
Annexure
Yes,
1.
let's page 23.
That is OA numbers.
260 is the code number of cat.
Yes,
which
10 minus
that they
5
got now?
511 and 581.
511, OA numbers 511 of
18.
2018.
18
And 581.
and 581 of
2018.
2018. Whereby, wait a number. Why this all the circular numbers? Yes.
No, they put the code number for every tribunals.
What you talking about? Read properly, loudly, so that they can listen. Read sentence, first sentence. No,
This is not the case. Which one?
which are the impugned orders? Sir?
Annexure 1
Annexure
is
1, page
page 23.
Till the OA number?
OA number 511 and 581 of 18.
Two OAs you have filed.
Yes.
No, two petitioners, two OA. Common order was 81, 511. First is 511 is mine. Item number 1.
WPC 23898. WPC 23898. You see that?
2389.
Second
Where are you going?
Yes.
You are going in
Second
different ways.
requisition.
Yes. Here you see. Yes, number 8. 1. Oh, yes.
Yes, Annexure 1.
Petitioners, being the part-timers, are knocking at the doors of Red Court for assailing the common order dated 9/7/2025, whereby their OA numbers 260 of 2018,
511.
581 of
So
2018,
260 is the code. 260 is the cutoff code.
511,
Yes, yes.
500 OA numbers 511 and 581 of 2018 have been negative. First time. In the said OAs, they had made the following prayers. It is page 26, Romans 1, 2, 3. Roman 1, 8. Following principal prayers. Page 26, Romans 1, 8, 2. Next paragraph. Learned counsel for the petitioners submit that in the earlier round of litigation, they had, that is in OA number 399 of 2017, disposed of on 24/11/2017.
Sir,
Is it?
Annexure 8.
No,
sir.
that is Annexure 8.
8.
Disposed of by 24/11/2017.
Sorry.
A direction was issued
Yes.
to the respondents, to the OPs, to consider presentation dated 25/5/2017, wherein inter alia they had sought for their enlistment in the, which is that scheme?
Third,
Their enlistment in the place out of the scheme,
out of this.
out of the scheme.
Out of.
Semicolon. There was a direction to consider the same, and that having gone against them, they had again approached the CAT in OA number
511 or 582?
No.
Annexure 1, sir.
Even before that.
238 of
238 is the Annexure 8.
That's the what
238 of 2011. When this order was passed, this 12 is then. That was the order in 2000.
After that, they find a repetition which is in Annexure 70.
Last sentence, what you do? No, consider the same thing. For placement, as sought for. First one. Thereafter, petitioners' representation, regularization of their services came to be negative by the OPs, as a consequence of which these ways had been filed. First one. He also submits that regardless of denial of relief of regularization, the petitioners cannot be worse off for the order made by the tribunal in the early round of litigation. First, learned DSG appearing for the OPs resists the petitions, making submission in justification of the impugned order and the reasons on which it has been structured. First one. Next paragraph. Having heard the learned counsel for parties and having perused the petition papers, we are inclined to grant a limited indulgence as under and for the following reasons. A. It is not in dispute that in OA number 238 of 2011, disposed of on 4/4/2013, the tribunal had observed as under paragraphs 3 and 4 at the page, running page 49. Next paragraph. The above being the position, the above order attained finality, there being no challenge to the same before any forum. First one. That order had given the whether both applicants were there.
Yes, both of them.
These the petitioners.
One way, both petitioners.
Both are petitioners. What have you written? Petitioners, the relief, namely, enlistment of their names in the suitable places in the third category of the subject list, prepared and published on Exer 5. Date is what?
But my lord, this is for a moment. Let's see Annexure 70. Somebody repentation is there.
No, that is subsequent to
No,
this.
assuming that one fits one. Now they will make a representation because this is at a final.
That can be.
Only need not mention an example. First one. Therefore, the impugned order now passed by the tribunal cannot be fully justified. First off, in other words, though the relief of regularization is denied, the order could not have been structured in a way as to dilute the relief granted to the petitioners in the earlier order dated 4/4/2013. First up, to that extent, there is lacuna warranting rectification at the of this court. Next paragraph. All the above being said, counsel for the petitioners agree that they would also raise representation for their engagement on immediate basis, excluding the mediary, namely the agent, the service provider. First off, if such an application is made, the court jurisdictions have to take a call thereon, keeping in view the extant policy concerning the matter. First off, next paragraph. In the above circumstances and with the above observations, the petition is disposed of. First off, time for making the representation is 4 weeks, and for consideration is 6 weeks from the date the same is made. First off, all contentions of the parties are kept open. No courts.
That agency name is Raj Manpower and Consultant. You'll also indicate Raj Manpower.
Namely,
Raj, R-A-J, I am giving in writing.
just give it in writing.
Manpower and Consultant.
60 to 80.
Okay.
Item 2, WBC 2095 of 2026.
Raj, you can see, you said, na? One sentence you had. That would entitle the petitioners to the higher amount of remuneration by excluding the commission which the mediary would have charged.
They're charging almost 40% of the amount.
Anyway, we have said that, yes.
Next.
Item 2, WBC 2095 of 2026.
Petitioner challenge the order passed by the Donald Central Administrative Tribunal Court of Inspector in OE number
229 of 19.
yeah.
What was that way for?
They have taken it, they are challenging the past service of the adult employment that may be counted. Initially, the petitioner was appointed as a LDC on temporary basis on 1/1/1992.
1/1/92
under Annex 4, my lord.
LDC temporary basis.
On 28/7/2004, his post was regular.
28/7/2004.
2004.
He was regularized.
Yes, my lord. On 28/7/2004. Thereafter, my lord, he is continuing. All of a sudden, the Registrar General of India passed this order on 3/17. My lord, kindly come to the page, my lord.
Your date chart does not have that name or that date at all.
No, my lord, it is the first time it will come and
Okay. No, one which you had produced tribunal.
tribunal.
Anyway, 3/10/2024 is there.
Yes,
You
ma'am.
said 3/11?
3/11/2016, the earlier the respondent challenging the order passed by this. My lord, kindly come to the Annex 2, page 64. On 29/9/2017, that order was under challenge.
This is 29/9/2017.
17. Office of the Registrar General of India.
What it said?
Just says, my lord, the ad hoc period is not counted.
Ad hoc
Ad hoc period, my lord.
is not counted for what?
For MSB and RSB.
Similar matter come before lordship out of 8. This is left out, and that also implemented by the department. I am for the opposite party, your lordship.
You are for the opposition.
Yes, sir, also.
That petition has to be allowed now.
Yes, lordship. Already,
Are there orders?
yes, all are also implemented.
You have to copy them.
Give that.
First and second page.
These are the only matter left out.
Yes. I also given the implementation program.
That Bombay High Court judgment
Yes,
and
yes, Lord.
the another is
Yes, Lord.
that.
Also implemented lordship. Can you say implementation?
After passing of this judgment, they have implemented.
Yes, yes, yes. तथ्य देखता दे लीजिए सेकंड की जरूरत सिर्फ
Implementation.
आवड़े के
My lord, I pray one thing, my lord. My lord, it means solve a copy just now. They'll take it up next week.
No, it is the same.
Mr. Naik, it is the same.
We want to give the relief to you and still you want time. For the central government.
Yes, my lord.
But then where is that? It's covered by the judgment.
Yes, my lord.
Exactly. Two high courts have held against you.
My lord.
That has been followed by the Cuttack bench.
Yes, my lord. My learned friend.
No.
Having a judgment in the Bombay High Court.
No,
that case
also.
Yes, that is technically
MAP and recipe.
If there is anything, you seek review. We'll permit you now.
Yes, my lord.
Yes.
The Bombay High Court, his service was not regularized. He was challenging this order.
Take down. There is nothing left. I did. Only one matter was left out. That's all. The subject matter of this petition is substantially similar to the one in WPC number 5227 of 2025 between India and others versus Tapan Kumar Pal, heard and disposed of by this bench, by the judgment dated 10/2/2026. 10/2/2026.
With emphasis analysis.
First one, the operative portion of the order reads as under. Things.
My lord, I pray one thing, my lord. My lord, the order was passed in WPC number 5227 by 25 5943 8593 and 8934 of 2025.
Yes.
Common order was passed by your lordship.
Yes.
Yes.
My lord, kindly come to the paragraph 4.3, my lord.
4.3.
My lord.
Where you are referred to Jago Umadevi.
Yes, my lord. What has happened? His port was regularized on 28/7/2004. He was already regularized as a service. My
What
lord.
you have granted? Yes.
My lord, I read it, my lord. If your lordship permit. Yes, my lord. The vehemental contents on the London DSJ and also London Senior Penal Counsel that Ummadevi there is a big shift in the law relating to the regularization of service in public employment, and that the impugned judgment of the tribunal do not accord with that jurisprudence is very difficult to countenance. It hardly needs to be stated that law is a social institution. Water,
Static water.
it is more like river. Ganga, which keeps flowing, Umadevi is not
Where are full stops, comma, not taught to you anything.
following. Umadevi is not the destination point. At the most, it was only a traveler's inn. Law has merged from April to May, and now the June of his life by Jago versus Union of India 2024 IS and Dharam Singh versus State of UP 2025 Sasanad Sipal Ghaziabad and Bhodanath versus the State of Jharkhand. This judgment, my lord, they are contractual employee, their port was not regularized. Your lordship passed this order. But he, in this case, his port was regularized on 28/7/2004.
Whatever benefit you have given to these people has to be extended to that person.
From 2004 to onward, my lord, he is getting all the
We
benefits.
will not say anything now. Whatever benefit we have given here, this order has attained finality because you have implemented the order. You have implemented this.
That time, my lord, that their service was not regularized. They are challenging this.
So, they are not, those who are not regularized stand in a better position than those who are regularized.
No, my lord. Those are
They are worse off.
Yes,
To
my
them benefit is granted.
Yes.
Here is a person who has already secured order of regularization.
Yes, my lord.
Therefore, whatever benefit you have granted to these people, that we are extending to him. We don't say anything.
Yes, he told that 1192 when he was initial appointment, that time he.
What you have written? That's it. First stop. Next paragraph. It hardly needs to be stated that in identical cases, identical relief has to be granted in the adjudicatory process, subject to all just exceptions into which argued case of the petitioners does not fit. First stop. The above part, learned counsel of the employee has placed on record office order dated 9/4/2026, whereby the above judgment has been implemented by granting benefit to the litigants therein. First off, the said order reads as under.
Implemented order.
Below that, one more sentence. Further, in the case of other employees who are similarly circumstanced, other implementation orders have also been passed. First one. Next one. In the above circumstances, the petition itself being devoid of merits is liable to be dismissed, and accordingly it is. Coupled with a direction to implement the impugned order within an outer limit of 8 weeks, as has been done in the case of similarly circumstanced employees, without driving the OP employee to take recourse to law for implementation. Take this.
Item 3, WBC 9925 of 2026. Thank you.
Huh?
Lord, my lord, am I audible?
Yes. Order has been passed.
This, my lord, this matter was already listed and notice is being issued. It's been adverted. My lord, I think it is inadvertently listed again, my lord. My lord, on 2104 it was listed, my lord. Wherein your lordships have passed an order, the notice has been accepted by Mr. Padhi for OP number 1 and 3. The rest have been returnable within 3 weeks.
All right.
This is-
Since
My lord,
order is already made yesterday
day
for
before.
admission, come on, no further order required. Okay.
Now, may I just request one thing, my lord? In this, your lordships have
Yes, sir.
indicated three weeks time returnable. Can it be fixed on 14th of May, my lord? 14th of May,
No, in this stage, we don't fix anything. Yeah.
my lord.
Item 4, WPC 12046 of 2026.
Pleasure.
Ah.
And for the petitioner, matter. In this case, the petitioner wants to clear the entire amount of outstanding of the bank. If a reasonable time has been given, there is a sell notice has been published, my lord. The petitioner took an instruction from the bank that that was not addressed, no bidder has come. For that reason, the auction was not held.
Then petition has become ineffectual.
No. I am praying to pay the entire by 20.
You are the borrower.
You go and pay. Who prevents you?
My lord.
You go and pay.
No, my lord. If a reasonable time is because his father is ill, for that reason he is a.
You make a representation to the bank
Yes, my lord.
mentioning all that.
Yes, my lord.
Then bank will consider that.
Yes, my lord.
That's all.
Yes, my lord.
What do you say? Petition prayer reads and text paragraph. Learned counsel for the petitioner submits that now the scheduled auction having not materialized, liberty be reserved to the petitioner to make a representation to the bank offering to settle the outstanding once for all by granting easy installments. First time. Let the panel counsel on our request appearing for the bank submits that if such a representation is made, there would be no difficulty for considering the same in accordance with the RBI guidelines. Extend RBI guidelines. First off, this is appreciable. Next, with the above observation, petition is disposed of. Next.
Item 5, WPC 12127 of 2026.
Time he will submit this.
Don't worry. If it doesn't,
Even 7 days you will have.
yes, that's fine.
He wants to clear all these things because property cost is 1 crore 80
Yes.
lakhs and loan is 22 lakhs only.
One line. If representation is made within 1 week,
Yes.
the bank shall consider the same in accordance with law within 4 weeks. First off, all contentions of the parties are kept off. Done. Next.
Item 5,
Please, my lords. Let's here challenge the section 14 application for taking of possession of the property. My lords, this comes out of a home loan which was taken by the petitioner with principal
On
on, my lords, 29th of September 2019.
You are a borrower.
My lords,
how much?
it was 85 lakhs.
How
Well,
much
it's-
money you have repaid already?
My lords, I will come to that, but we have already
Answer this
repaid.
question.
My lords, I have already paid around 39 lakhs.
You have paid 39 lakh.
39 lakhs, some odd I have already repaid. On February 9, 2026, the bank has given us a statement. They have filed this application section 14 and they have stated that around 93 lakhs some odd is pending to be repaid. Now I'll come to the rest of the part. Just as a background, I want to submit.
Yeah.
This person, petitioner, is not a willful defaulter. She's a woman, she's a homemaker, housewife. Who, in 2019, some catastrophic and unfortunate mishaps happened in their family.
What is that?
That is, the husband first suffered from brain stroke and he became completely paralyzed. There are two children, one son, one daughter, both are studying. She is a homemaker. After that, COVID-19 came. She was somehow collecting rentals from different properties and also selling off properties in order to pay the loan amount, whatever she has paid until now. Thereafter, she also suffered from brain stroke. She became partially paralyzed. Somehow, that it's mother's courage looking at the daughter and the son, that she somehow through physiotherapy exercises, she recovered. Again started paying. I want to show my bona fide here, my lords. There were 5 loan accounts. We have already finished paying, my lords, against 3. 3 loan accounts have already been closed.
Out of 5, 3 are closed.
3 are closed. We have paid around total 1.10 crore. Only 2 loan accounts are left, out of which this is 1 loan account that they have challenged before the learned DM. My lords, I am ready and willing to pay the rest of the amount. But the only thing is, because of this problem that they are facing right now, being a homemaker, we are willing to deposit 50 lakhs upfront within this 10 days of time if your lordship permits us. After that, what I humbly propose is that my lords may refer this matter to will get it settled, my lords, because they are not giving any sort of written document to us showing
what document?
Written statement that as to this is the amount that you need to statement of account, not statement of account, a piece of letter where they will confirm.
But they will give statement of account.
My lords, that they've given. This section 14 application reflects a statement of account.
What
My
is
lords,
to be given?
50 lakhs, I am ready to show my bona fide that I will pay it.
Out of what is
93 lakhs some odd.
93 is due now.
Yes, outstanding due.
In respect of 1 account.
Yes.
Another account?
Something around 60 lakhs. So we want to completely settle the ballots, both the accounts, by giving around 1.5 crore is what we are proposing. But that is a separate thing, Malots, against this account particularly because this is under challenge right now and they're residential property, Malots. It's a residential house. Malots, again, in order to show my bona fide, just I think my learned senior will also place that matter, but before that I want to come clean. Once there was a writ petition filed where we had asked this on they requested this Hon'Ble Court to allow us to regularize that account. But somehow this woman could not, Malots, repay. So we faulted, but to most extent we have already paid that much amount. 30 lakhs was fixed by this Hon'Ble Court. We have paid 24 lakhs, but not within time. That is what I concede. But currently we have collected the funds. We are ready to give 50 lakhs. If your lordship is fixing a time limit within 10 days, if your lordship is adjourning the matter, I will come with a proof that 50 lakhs has been deposited.
No, you should have gone to the bank itself with the money back. Perhaps they would have
because we are collecting right now. This is at the verge of the fact that the DM is going to pass orders to take possession. That's why, my lords. Only 10 days time.
Anything at all.
Only 10 days time. We have already sold a property. She is, my lords, suffering, my lords. Just 50 lakhs of rupees will immediately give within 10 days. After that, it can be sent to Lok Adalat for settlement.
No.
That's what I humbly believe.
What bank will say. Yes, Mr. Let him pay 50 lakhs.
No, he had approached this Honorable Court.
He said that.
In March. Thereafter, he filed an essay also before the DRT. We also filed an objection giving all this complete statement account, everything we provided in reply to that. Matter is fixing on.
That was against another account.
The 29th of April.
Not in respect of this account.
No. Is it our account against?
What I suggest is.
One account is NPA, all the accounts are there.
No, it's all right. 50 lakhs he is ready to pay now. Let him give a representation to you. You consider that. Till consideration takes place, don't precipitate section 14. You do it within 2 days.
If it is passed also, we will not execute it.
Very good.
We will not ask
If he gives 50, you can other things you can negotiate with.
Obviously, we are fair. We will not give money.
That against 2 loan account and against 1 loan account he is having
93 lakhs. Another
If he is paying 50, that means almost 1 account is going to be closed.
You close 1 account.
That is yes, suggesting means I need to get it by March when the matter was This
No,
date,
yes, there is
March 2025,
True.
1 crore 44 lakhs was the due. So it is 1 year past. So maybe 165, 170 will be there. Whatever.
And it's still-
Still, Lordship suggests, my lord, you
That
can
can be
deposit
done.
50 lakhs within 10 days with a proposal with the bank. So balance amount, how he's going to pay.
Yes.
And within 1 week or 2 weeks, my lord, we will also dispose of
50
it.
lakhs not at a time, 20 lakh within 1 week, 25 lakh in another week. You can't go 15 days and then all of a sudden you will going.
No, within-
You may do other
My lord,
mistakes.
he suggested 10 days, he'll deposit 50 lakhs. My lord, let him deposit.
No, but no. The way no, it will not happen. Then it will be open to you to take all action. Only it's like buying time. That's all.
This woman has
There is a lady
yes,
who has suffered, her husband has suffered.
around
There are
2
two
crores
children.
have already
Anyway,
paid.
he is saying that he has sold the property. She has sold the property.
Yes.
Perhaps the proceeds will come.
Yes.
Otherwise, you will take action. We'll make it pass.
Grateful, my lords.
Then you will not oppose that section
No,
14
my lords.
application
No, my
at
lords.
all.
We have already paid around 2 crores of amount towards all those loan accounts, my lords. We are slowly and steadily we are paying everything.
Petitioner, borrower has coined the prayer in the petition as at. Next. Regardless of what has been prayed for, and also disregarding the pendency of SA, and also other orders of the court or counsel for the petitioner submits that his client shall credit to the loan account. Which loan account?
This is, my lords, a home loan account.
Home loan account. A sum of rupees 50 lakh in 2 weekly equalized installments, that is 25 lakh each, and would make a representation to the bank for considering the proposal for granting installments for clearing all outstanding monies, loans. That is, loans in respect of 2 accounts, both accounts. Once for all it will be over. Otherwise, one more battle there, another battle here.
My lords.
First. With this, first, learned panel counsel, Shri, appearing for the bank, although initially opposed the petition, now agrees with the suggestion of the court that request of the petitioner be considered should he keep the words given to court, keeping in view the extant RBI guidelines. First off, he caveats that all contentions of the parties be kept open for consideration. First off, in the above circumstances and with the above observations, petition is disposed of.
One default, bank shall be in a position to take action.
Making it clear that should there be a default, the bank can proceed with the coercive actions.
Until this 2 weeks of time, my lords, the section 14. That section 14.
2 weeks.
Yes, that 14, section 14 application, my lords, order may not be passed in.
Till then, it hardly needs to be stated that no precipitatory action shall be taken in the matter. Over.
My lords.
You should go with the bank. Bank officials are not the Pakistanis.
My lords.
They are our own officials.
I totally
They have lent money.
Yes.
It is their duty to recover it. Otherwise, action will be taken against them.
Yes, my lords.
And we will also take action because it is a public money.
Yes.
And coming to writ court and shedding the tears here, every parole.
No, the RBI is imposing crores of fine against the banks.
That's why. It's a public money. Our money, your money, everybody's
Yes.
money.
Extremely grateful.
And teardrops are not equivalent to repayment of the loan. Yes.
Extremely grateful.
Item 6. Rate Appeal 139 of 2024.
My lord, it's an appeal filed by the state, my lord.
355 days delay.
My lord.
What is the main point?
Main point is matter is covered by your lordship's order.
Which is that?
This is that Krishnachandra Malik's case.
Yesterday also.
Yesterday, yes.
The subject matter of this state's appeal is substantially covered by our judgment dated 15/7/2025, entered in writ appeal number 17 of 2023, etc., between State of Odisha versus Krishna Chandra Malik. Next paragraph. In view of the above, this appeal is also disposed of. Not much adverting to the delay proved in filing the appeal. With the same terms and conditions have been enumerated in Krishna Chandra Malik Supra. Registry to send a copy of this order. Whether it's served?
No, it was not.
By speed post, immediately. Okay.
My lord, 7, 8, 9.
7,
8,
8,
9,
9,
10, 11.
No, 10, 12, 13.
10,
12, 13.
30, not 11.
11, this is not Supadan.
Not Supadan. Same order?
Yes.
Same order. 7, 8, 9, 10, 12, 13. Same order. What?
11 is covered by Norsu Pradhan's case.
Take that.
Impugned order. It is mentioned in the impugned order. Page 11.
WA is mentioned.
Page 20. Similar benefits as given to Norsu Pradhan is.
The subject matter of this petition is this appeal is substantially similar to the one in WPC number 5377 of 2010 between Narusu Pradhan versus State of Odisha, disposed of by the order dated 19/12/2011 by the court. First off, we are not shown that this order of the coordinate bench was put in challenge and put in successful challenge. First, Lovelet single judge has structured the impugned order, keeping in view the said decision. First up, in the above circumstances, this appeal being divided of merits is liable to be rejected, and accordingly it is both on merits and delay. of 397 days, for which there is no plausible explanation. First, order of the learned single judge shall be given effect to within an outer limit of 8 weeks. First of all, registry to send a copy of this order by speed post, same order. Okay. Next.
Item 14, Date Appeal 3429 of 2024.
In my lord, it's a state appeal wherein there is a delay of 804. But the matter wherein it is challenged, my lord, this is challenged the Honorable Single Judge dated 8/9/2022, my lord. Here, my lord, one advertisement made in 1995, my lord.
I think even this matter is we have considered
that my lord has considered in some time that Ananda's case. But here, my lord, they have been selected and subsequently they have been appointed. Even after completion of the period of 6 years, he has also been promoted to the post of senior clerk. That is not the dispute one. Fact remains, since 2000, the merit list was prepared, but they have joined in 2007. Keeping in view the joining date of 2007, subsequently he was promoted to the post of next half post.
What is his fault? After merit list was prepared in 2000, why did you delay the appointment?
Question is, the judgment relied upon the order of this Honorable Court in the separate matter under Annexure 2. Therein the matter is totally different, madam. Therein the junior persons have been given appointment and promoted. This petitioner has not been given. But in the instant case, madam, the petitioner nor any of the juniors have been given appointment. They have been first given appointment because out of the 79, this petitioner, the respondent number 2, madam, is at serial number 9. In the first phase, he has been given appointment in 2007. None of the candidates have given appointment much prior to that. But the Honorable Single Judge relying upon the judgment, which is at Annexure 2, that is ON number 1612 and 1613, therein less meritorious and the below ranking persons has been appointed, which is different in this particular case.
Whether in respect of these people,
yes,
whether they were given appointment with retrospective effect?
No, my lord. They have all been given on 12/3/2007.
On the same day?
Yes, ma'am. Because these
2007.
12/3/2007, my lord.
Why is the delay when...
delay, my lord, in official. Though selection was made, final list was prepared in 2000, but none of them has been given appointment.
Why it was not given?
Because of the government requirement and all other things for the system, my lord, none of the candidates have been given appointment from that merit list.
Why not given? Merit list has to be operated within 1 year.
My lord, that has been extended, my lord, up to 2007, my lord.
We are asking why it came to be extended.
Because of the requirement.
No, you send the requisition to the OPSC on the basis of availability of vacancies.
Yes.
If those vacancies arose, only then you will ask the APSC to go for selection.
So selection was made.
Selection. No. Why for 7 years government slept over the matter?
Because of the financial, all other things were
material.
None of the candidates have been appointed.
That's true.
In first phase.
Why not appointed?
My lord, in Sankarshan Das case versus Union of India, even though they have been found place in the selection.
No right to appoint.
Exactly.
But correct.
It has not been created individual right.
No, that we wish to a great
We are not saying, with due respect, we are not saying that they have not been appointed, they don't have been right. We have been appointed. They have been appointed in 2007. They have given also in the promotion, my lord.
That's not the point. Why you denied appointment for such a long period? Explanation in the matter, not the oral cathedra statement. What is the ex cathedra statement? You have to show that.
But
where have you stated in your reply?
Honorable Single Judge, my lord, Honorable Single Judge, basing upon the another judgment, this judgment
I say
that is not same.
That may not be.
They are in different status. Because some junior persons have been given appointment, on that score this has been passed. But here in a case, because the respondent number 2 is at serial number 9 out of the 79 candidates. It is not the case, my lord, some other junior persons, others have been appointed. In phase manner, appointment can a decision also extended the validity of that period, not for 1 year, up to 2007. In different phases, they have been given appointment, and this person also
Earliest person was granted appointment when?
In 12/3/2007, because petition is at serial number 9, not that is below the rankable, 9 only.
Issue heard learned counsel, learned AGA, Mr. Mohanty. First, issue emergent notice on delay application. If the appellant's deposit the amount for the delay in the registry calculated at the rate of ₹20 per day of delay within 2 weeks, failing which application stands rejected, and as a consequence, appeal as well. First of all, post this matter immediately after 3 weeks for a possible dismissal. Compliance is not done.
Malad, IA is there, Malad.
Therefore, on IA, 800 odd days, if you deposit money in the registry, then the notice will go. Otherwise, we will dismiss it on that.
No. Malad, both. Read appeal as well as in the IA.
Issue notice both on IA and main matter. IA and appeal.
Item 15, Read Appeal 117 of 2025.
15, Lord, it's a state appeal.
Yes.
That is rehabilitation assistant,
Yeah.
Of course, subsequently the same has been taken a decision after the April 2025.
Covered by that Malayalam city.
Malayalam city, subsequently Jita Lua came in there.
So there is nothing. We believe, we assume that the similar matter we treated.
Well, similar matters has been taken care of. But here they are saying that because this application is 2014, Milon. 2014.
So 2014 is not guided by 90. That is guided by 90. Even the amended notification has taken care of the
April 2000.
applications which are after 2000. The death has occurred after 2016 and before 2020.
That apart, see the operating portion of the order.
Yes, ma'am.
For consideration.
For consideration.
This intra-court appeal by the state, calling question, a learned single judge's order dated 3/8/2023, whereby respondent employees WPC number 23467 of 2023 having been favored, the following following relief has been accorded. Next paragraph. Having heard learned counsel for the appellant, and having perused the appeal papers, we notice from the text of the operative portion of the order that it is an order for passing the order on remand and nothing more. Keeping in view the decision of the apex court in Malaya Nanda Sethi versus State of Odisha 2022 2 OLR SC 1, and also State of West Bengal versus Devabrata Tiwari civil appeal numbers 8842 and 8855 of 2022 disposed of on 3rd March 2023. First off, such orders do not merit the deeper examination at the hands of the appellate court. Appellate court. First off. Next paragraph. The above part after noting a long delay of 493 days. First off, an application in IA number 127 of 2025, supported by affidavit, has been moved, seeking condonation thereof. First off, a perusal of the application and the affidavit would not show any plausible explanation. First off, therefore, the application is not well founded. Not well. Application thus is not well founded, and therefore is rejected. Next one. In the above circumstances, this appeal fails both on merits and on feeling. Okay. Registry to send a copy of this order. One more sentence you have to add. The impugned order of the learned indulgence shall be given effect to within an outer limit of 8 weeks. Okay. Next.
Item 16. Tribunal Appeal 230 of 2025.
16 will not. This is to be.
Pardon, my lord.
Yes, sir.
The present petition has filed CRLA number 23 of 2025.
Yes.
Due to inadvertent mistake by order number 2, it has mentioned CRLA 183 of 2025.
The number reflected that maybe.
By the coordinate bench.
Yes.
By my lord, just that's it.
183, it should be 230.
So it will be corrected as 230.
Only that.
And connected.
Yes, CRLA 183 should be. Where is your application? 2080.
Order mistake, then it's.
Oh, that comes before. The officers move this matter on list for a correction in the CRLA number 183 of 2025, left in place of CRLA number 330 of 2025, which is allowed accordingly. And the CRLA 183 of 2025 is read as CRLA 230 of 2025.
And I may pardon, the connected appeal CRLA 183 of 2025 has been posted to coordinate bench on 8/5/25. I pray, madam, in the meantime, state be directed to obtain the custody.
Where is the state? Who is there for the state?
No, if fatality will be placed. Definitely.
Then we'll see. We can't pass order because it has come from
My lord, in that observation also, in the noting, it is also there. Digital copy of the TCR attached here with in paperless mention. Possibly it is in the process.
It has come
So,
to office.
From the state.
You make a mention, we'll make a mention. It has come through.
Waiting for upload.
Next.
Item 17. WBC 5753 of 2006.
item 17, my lord.
Yeah.
It is a matter of 2006.
Just
From my friend Vigin.
question our memory. 1963 rules, something you said
Yes, ma'am.
yesterday.
That, my lord, here what happened?
This was disposed examination.
This
we remember.
was disposed of. So the registry is lacking the document because it has been referred to the record room. My lord. May I take the assistance of my friend or in the court copy? May I?
Yes. To take that. You want time?
Like that, yes. Monday, I don't pray 6 matter. I am conscious. Monday, Tuesday, any day.
Yes.
And I am permitted to take that copy. In soft copy also I can collect because the
Registry to furnish soft copy of the case papers.
Like that I
to
can
the
make
learned
it.
AGA immediately. At least you can also give one.
On my own question, I can take it back. No, because 2000 concession, not necessary. I have given, I can give.
Counsel for the petitioner very graciously agrees to furnish a copy of all the case papers to the learned AGA. First stop. Call this matter next week. Yeah.
Item 18, WBC 17510 of 2025.
Yes. Password.
Matters, if your lordship is not inconvenient matters, with great humility, may I submit that this matter may be kindly taken up on Monday, 27th.
Monday? Call it on Monday at the request of both sides.
Obliged, my lord.
Item 19, WBC 29490 of 2019.
Adjournment. Not ready.
Not ready.
The second week of.
Second week.
At the request of.
Item 20, WBC 14253 of 2022.
The learned deputy consul general was to had taken adjournment to this matter last occasion.
You want time?
No, my lord. I want to do it, my lord. Subject to.
Other state is not here.
No, the deputy had.
Yes. We'll call it in the second week of May.
I have only one. I have come innumerable times in this matter. And apart from that, my lord, I have a difficulty because they're very poor people, my lord. I am doing it pro bono. And difficulty is that, my lord, last time, my learned friend said that I want some time because of the written note I had given. I had given the written note. They have must have seen the written note. Then my lord fixed this date today only for that.
Five.
Any date.
Will it be convenient? 5.
No, whichever date, my lord, otherwise I'll do it, my lord, on online if at all I'm not here.
5. To enable the DSG to 10 matters are there. Yes. Yes, Mr. Paddy.
Yes, ma'am.
You had fixed the date.
Yes, ma'am. 5th is fine. I heard that, my lord. My lord is between 5th.
My learned friend.
He is behind the curtain, watching the old proceedings.
Yes.
Item 21, need appeal 35 of 2024.
21 minutes I'm for the appellant. My learned senior, she's appearing online. And Lordships appears for the other side.
Lordships, it is that matter where we have that jurisdiction issue involved as well as. Lordships, I think this is last they supposed.
After vacation.
Lordships.
Some complexities.
Lordships.
In third week of May, will you do that?
Lordships, third week of May, please.
On 19. 5. Yes.
Item 22.
Yes.
WBC 17676 of 2024.
May I please, Your Lordship?
Yes.
This issue which arises for consideration is a short one, which is interpretation of a particular clause, which is clause 4 of part 9, which says if there is a stoppage of mining operation, the period has to be added back. So it will be my endeavor to show to the court that there has been a wrongful suspension. And if I am right in that, the period I have lost, which is 5 years and 10 months, have to be added back. Note at flag C is a note of submissions which we had given for the court's kind consideration.
Flag C.
Yes, I believe, my lord.
What is what the law of leases under the Transfer of Property Act says about this?
No, the Transfer Property Act doesn't apply at all.
Does not apply.
I just explain. Just give me 2 minutes. I make the point short.
Is it not a lease?
Just give me 1 second. Issue is slightly different. I'll just articulate it and then show you, but I'll answer the question first and then put it in perspective. Lord, we have the EC dated 22/9/2004, environmental clearance. This environmental clearance, it was court of the lease and valid.
It is court terminus with the lease.
Just permit me to just state the point. I'm answering the question. Another EC, my lord, was issued on 29th October 2008, but it was conditional. It never sprung to life. It was never implemented. The respondent, on the basis of this EC, stopped by mining operation, right? But it is 2004 EC which holds the field. Central Election, CEC, Central Empowered Committee, Ministry of Environment and Forest, and the Supreme Court on the CEC report all act on the 2004. By virtue of acting on a EC which was not sprung to life and which was conditional, he stops my mining activity for 5 years and 10 months. That is covered under the lease at page 134 under a particular clause, which is clause 4 of part 9, which says this period will be added back. This is the short point. I was only answering my lord's question. Now kindly have that clause straight away for a minute at page 134. This would be perhaps not annexure 6. I'm just showing the relevant part straight away. Clause 4 of part 9. My lord has that.
Lease is delayed. The period of such delay shall be added to the period fixed by this.
Yes, exactly. Right? That's the clause. Now just note, my lord, 2 things. The EC of 2004 is 22/9/2004, which my lords will get at page 139. But I'm just giving a snapshot here, and then I'd just like the court to go through the notes. So it will be, but I'm just showing you the point that it is not. 139, my lord has?
Yes.
139.
Yes.
Yes. Lord, kindly just see the date, 22nd September 2004. We have page 140. Next page. See, next page. Please have specific condition, capital A.
The same
20 years clearance.
Environmental clearance is for 20 years and fresh clearance would be required at the time of renewal of the deed. Right? So this is for 20 years. Just now have where the problem arises, page 159. This is annexure A.
Yes.
Kindly see the date, 29th October 2008. My lord sees that. Now kindly have page 161. Specific condition.
Pollution control, environmental clearance.
Yes, ignore that. EC is subject to grant of B. Number 2.
Subject to grant of forestry clearance.
So it is a conditional EC, right? Just stop 2 minutes. This is the short point and bone of contention that this 2008 EC did not spring to life, and Gopaljan is not saying the Central Empowered Committee, the Ministry of Environment and Forest.
Central Empowered Committee means
setting up by
the Supreme Court.
Yes, I'm just sure. So this is the point exactly as my lord asked. Now, my lord, kindly just see the mistake at 169. I will show why it's a mistake. I'm just giving a quick bird's eye view of the bone of contention.
Suspension of mining operation.
Yes, my lord. This is annexure 9. My lord has that?
Yeah.
With reference to the
Expired on 31/3/2014.
correct, relying on the 2008 EC, which my lord see in the second line, 2910.
Which is not for 20 years. That is not the VC.
Yeah, but it didn't spring to life. It's not. Just give me 2 minutes. It'll all be. Just only.
No, we want to have clarity.
Yes, I'm showing my lord. Just documents. So 29/10/2008. On that basis, he says it's expired on 31/3/2014. Correct?
Sir.
Now just have 3 pages and it's clear. 249 first. Annexure 12. At page 249, para 147. My lord has para 147.
Yeah.
The CC is of the view that the said environmental clearance dated 29th October 2008 becomes valid only after approval under the Forest Conservation Act 1980 is granted for the diversion of the additional forest land for mining and allied activities. Till then, enhanced production of 15 MMT provided for in the said environmental clearance was not permissible. Any production by the lessee beyond the annual production prescribed in the earlier environmental clearance dated 22nd September 2004 should be considered as in excess
of the valid environmental
right.
clearance.
We are not on the excess. I'm just on the validity. So he says, I'm showing you 3 documents. Number 1, CC in the first line says it becomes valid only after FCA. Right, my lord? Now have 253. 15 January 2015.
Yes.
But kindly note the subject. This is in January 15. Environmental clearance issued by the MOEF dated 22/9/2004. This has reference to the letter dated 3rd November 2014 regarding the proposal of the petitioner for permission to mine in terms of the EC dated 22/9/2004. The petitioner was given an EC on 22/9/2004 for mining 4 MTPA iron ore lump of so-and-so hectares so-and-so. The petitioner submitted with the above letter that as per the EC dated 22/9/2004, specific condition number 1, EC is for a period of 20 and fresh EC would be required at the time of renewal of the mining lease. Further EC for expansion was issued dated 29th October 2008. The EC was issued for production capacity of 15 MTPA subject to the forest clearance. Next line is very important, which is yet to be accorded. This EC was valid up to 33/2014, which my lord saw in that impugned wrongful suspend. Now see the next one. In view of the above, the matter has been examined by the ministry and it has been decided that the petition to mine in terms of EC of 4 MTPA is approved subject to the permission from the Supreme Court. This permission of mine of the EC limit of 4 MTPA granted by a letter of 22/9/2004 will be reviewed if required after final decision of the Supreme Court on the ownership related issues as brought out by CEC and the Shah Commission. Right, Vinod? Now have the Supreme Court order at 289. Annexure A18.
Common cause judgment.
Yes, my lord. Kindly straight away come to paragraph 2 at page 290. My lord, the extracted paragraph is from the CEC report which I just showed you. The last line of para 2. The CEC submitted a self-seeking report dated
8/2019
about SMPL, which is the petitioner before the court. Right, my lord? My lord has
Yes.
that. Now kindly turn to the next page. Paragraph 4.
In light of these observations.
In the light of these observations, the petitioner contends that it is suffering irreparable injury and highlights how it has already lost more than 5.5 years and how hardly half a year of its lease period is left. Expressing willingness to furnish an undertaking or bank guarantee equivalent to its dues as assessed by the CC, the applicant seeks permission to resume mining operation. Upon notice, the Council for the State of Odisha and the CC expressed objection against granting SMPL's prayer for resumption, subject to its depositing the CC assessed dues, that is about 933 crores, which I've done.
Did you pay that?
Yes, 933 done, and I have a resumption order. I'm just coming. And strictly complying with all other mandatory rules, regulations, and conditions for conducting the mining operations. And on 30th January 2020, at page 295, is the resumption order. My lord is Annexure 19, 295.
This is a
Whether the Mines Department.
Mines Department of State.
Yes. It says on top, my lord, Office of the Deputy Collector Mines, Joda, District, Kyonjar.
Mines.
Kyonjar. My lord has Annexure 19.
Yeah.
Please see the subject matter, resumption of mining operations in respect of Thakurani iron ore mines over an area of 947 hectares as per the order dated 15/1/2020 of the Supreme Court. To the court. With reference to the letter, I am to say that as per the order dated so-and-so of the Supreme Court and as per the instruction of Director of Mines, you are hereby allowed to resume mining operation in respect of your mines over 947 hectares within the granted surface area and approved forest area, subject to possessing of all the valid statutory clearances. So I pause for a minute and I go back to the point with
This was January 2020.
Yes. I go back to the point I started with, which is 169. Just have 169 again.
Yes. Which is expired on 31/3/2014.
This is the, exactly, I'm grateful. This is the three errors: CC report, MOEF communication, which I showed, and Supreme Court order, which is based on the CC report, which is the 2004 EC. So this 31/3/2014 is the mistake. If this is the mistake, then 134 says the period that you have lost, which is 5 years and 10 months, gets added to the fixed period lease. So my whole case is my contractual right under clause 4, part 9 of the lease. I only had to show the court that this is because of wrongful suspension by the respondent. If I'm right in my submission, it's wrongful. This period has to be added back. This is the
sum and substance.
And I'll be taking my lord's note through the note which is at flag C. If my lord could now have flag C. I'm just, my lord, I just thought I'll give a...
You have given a thumbnail description of the case.
Yes. And if I may say on a lighter note, hopefully to nail it, not just thumbnail, but nail the point. And thumbs up from the court.
The entire, the jugular of the case.
Yes, madam.
Where the lease is for a particular period.
Yes.
And a part of the period is not allowed to be explored.
Correct.
Because of the fault attributable to the lessor.
Yes.
Then that part needs to be extended.
No, added back.
Added back.
Yes.
Yes.
I'm being careful.
Added.
Because in mining parlance, every word
counts.
So, and therefore using the
No,
word...
I remember one statement by Bertrand Russell, where he said, if language is not properly employed,
yes,
then what is said is not what is.
Yes.
And if what is said is not what is meant,
correct,
what needs to be done will remain undone or misdone.
Yes, exactly.
From that angle, you are right.
Correct.
You have corrected us.
Yes. No, I not correct.
Yeah.
I just made...
because this mining itself is a separate jurisprudence.
Yes, exactly.
The terminology will have its own shadow.
You know the tone and tenor of what you will hear. Therefore, I'm very carefully using the word prescribed in the lease document. My lord, this is my point. Now, my lord, with this, please have the brief note on behalf of the petitioners, which I find, which I believe is flag C.
Yes.
That could be
Can we revert within a few minutes?
Yes.
Yeah.
Grateful. flag C.
Yes.
My lord has that document.
Yes.
My lord, I have crystallized the issue in number 2. May I, with your lordship permission, skip that because I've already
Said that.
I've already said it.
Yes.
And now your lordship will just note this in 3 the dates, just so that we have the dates in hand. Lease deed 14th August 2001, 13th August 2021, 20th. I showed my laws a clause. It was operated from 14th August 2001 to 31st March 2014. Wrongly suspended, my lord, on 31/3/2014. I've shown the order. Therefore, could not mind, that is from 1/4/2014 till 31st January 2020, then the resumption order which I showed to the court. This period, my lord, is 5 years and 10 months, which I'm saying should be added back, right? So I've just now put it in dates. Earlier I had articulated the position. Now I've given dates. Now, my lord, kindly come to the next page. This is the sequence, and I'll just very quickly, my lord, run my lords through it. My lord, what I'll do with my lord's permission, wherever relevant, I'll show the document. Otherwise, for sequence, this broadly will suffice. If that meets with my lord's approval, I'll proceed in that manner.
No issue.
Yes. 11 to
You are very fast.
Sorry.
Kindly be little slow.
Yes.
Because many students will be sitting in the court hall. Many law teachers look at our videos, etc. Be slow so that we will also fully appreciate that.
Sir. The hangover of watching IPL, I will go back to test. 11th February 1999. The petitioner was issued a grant order for renewal of Block B for 30 years from the date of execution of the lease deed.
Yes.
Then, my lord, second is just a forest clearance. We skip it for the moment. Number 3, very important. 14th August 2001. In view of the grant order dated 11th February 1999, a mine lease in respect of Block B was executed for a period of 20 years to start with, and the remaining 10 years to be executed thereafter. Lord, I must just point out one thing.
Totally 30 years.
Sorry?
30 years.
Yes, 30 years. Now, this is the crucial now, serial number 4. 22/9/2004. MOEF granted the EC to us for enhanced production of 4 MTPA, which was valid for 20 years and was co-terminus with a mining lease dated 14th August 2001 up to 13th of 2021. So I just pause for a minute. That clause which I showed my lords, that is clause 4 of part 9 at 134, is part of this lease agreement, which is the contractual right I seek to enforce. And this,
whether these leases are having a statutory flavor also.
Yes, absolutely. It's issued, my lord, under the form, under the MMDR Act. I'll show that.
Not pure contract, private contract.
The lease, first is the grant order, my lord. The right comes under the grant order. It is then recorded in the form of a mining lease deed, which is in a prescribed form, which I will just show under the Act.
How courts have construed these leases as the...
Yes, I'll place those judges. Judgment also. Now, my lord, kindly have the most important...
No, this is only two. I do not have much exposure.
Yes, I'll do that.
But I can understand. I assume that way.
Certain.
What our question is...
Yes.
In the event you have any grievance in respect of contracts...
Yes.
Lease is a contract. Why can't you go to civil court and seek your remedy? Why writ court is our question.
Yes. I'm very grateful, Lord. I'll answer it straight. Should I just give an answer straight away? Number 1, the lease is issued under the Act. I will show. The grant order is also statutory, also issued under the Act. Number 3, this is the infraction of my valuable rights because the courts have held the right that flows from a grant order is a valuable right that the mining leaseholders holds. An arbitrary and illegal action of the government, which is of the respondent, which is contrary to the expert body CC, contrary to what MOEF, the author of the EC, says, and in my respectful submission, contrary to a Supreme Court order, is an ex illegality. Illegality and a violation of my rights under Article 14, inter alia, is sufficient for me to come to this court. Second, there is already a litigation round arising from writ on that balance 10%, which via this court is in the Supreme Court, and the issue of maintainability is not there. So writ is there, and I will conclude also by making it good. I always feel that when a query comes, I must first answer it straight away. So in one line, illegal action which is violative of my constitutional rights is very much pith and substance of what a writ jurisdiction is about, to prevent injustice to a party. So that's, my lord, my first level answer to the court's kind consideration. Yes. Now, my lord, just since my lord asked that question, we should just have the MMDR Act, Mines and Minerals Development and Regulation Act 1957. Yeah.
60.
Section? Yes. This is to show what
this is issued under Rule 31. Just
no, for what purpose you want to show it to us now?
No, my lord asked me that
Question.
it have statutory flavor, so I'm just showing it from that point of view.
I wanted to know whether there is any judgment of apex court saying these contracts have statutory flavor.
Right.
And therefore its court can examine all.
I'll also get that. No difficulty. So just note for the moment, my lord, under Rule 31 of the Mineral Concession Rules 1960. May I just read the rule for my lord's kind consideration?
Sir, 3. Page 82.
Rule 31.
Rule 31.
Page 82. 86.
May I read with my lord's permission?
Mineral concession rules are central rules or state rules?
And central.
Page 87, 88.
These are made under the Act.
Yes, ma'am.
MMDR Act.
Yes, ma'am.
88.
Yes, they provide for.
Now, my lord, please see where on an application for grant of a mining lease, an order has been made for grant of such lease, that is 11-99, which I just showed. A lease deed in Form K shall be executed.
So it has got a statutory format.
Exactly. And please have
Flavor
form,
there.
now just have Form K, which is part of Schedule 1. It's in a prescribed form itself.
Yes, understood.
May I
Form is part of the rule.
Yes. In the schedule, the form. So, and that is issued under Rule 31. So it is statutory format, and the law, as your lordship knows, when something is to be done in a particular way, it is only to be done in that way. So it arises from the statute, and 4 read with this is the grant order, which is 11-99.
If there is already, if question is no longer res integra.
Yes.
We need not spend time on that.
Correct. Yes. Right. So I will place the case law also, but I mean just responding to what the court asked me, and your lordship will also, my lord, note.
Your answer is the contract has got statutory flavor or statutory force itself, arguably.
Correct.
That way. Therefore, infraction thereof gives you a cause of action to knock at the doors of Supreme Court.
Correct.
That's your answer.
Yes, and I'm going to take it one level even higher. Under Section 4, just take it from me, of the MMDR Act, it talks about a grant, which is in 4.1.
4.1.
Yes.
Grant of mining lease.
Yes.
How the headline, the head notice?
Section 4, prospecting or mining operations to be under license or lease. This is a complete answer to what the court asked me.
It is a statute regulated
yes.
largesse.
Yes. And there's a judgment of Gujarat Potteries, which is here, which I will show. Supreme Court also recognized it. Just let me read one line. Just have the last line. Of a mining lease granted under this act and the rules made therein. So this, with greatest of respect and humility, said
the mining lease is granted under a central legislation.
Yes.
And its grant is regulated by the rules also.
Yes.
Therefore, they have got statutory force.
Correct.
So you need not be relegated to civil court.
Yes, precisely.
Any judgment on
Yes,
this point?
yes, Gujarat.
Just
Gujarat,
give,
yes, Gujarat pottery. This is action flag H. Flag H.
You have already produced that judgment?
Yes, ma'am.
Which
Paragraph 7 of Gujarat pottery.
25th.
Your Lordship have it?
Yeah, no, we are.
Keep it on. This flag H.
In your case only it is.
No.
In our case only.
Face it, no problem. We can remember.
I'll just read it.
Just give the citation.
Yes. It's 1967.
1967.
1 SCR 695. Flag G in the compilation. Your Lordship need not detain yourself at the moment. Para 7 is relevant.
Yes.
It is really the sanctioning of the lease, which amounts to the granting of the lease. The execution of the formal lease is in compliance with the legal requirement to make the grant legally enforceable. So section 4 is the grant order, which in my case is 11/2/99. After the grant order is given, the Rule 31 and Form K steps in which the formal lease is executed, which is in compliance with the legal requirements to make the grant legally enforceable. And that's where my lords...
Mental concession rules which year?
1960.
But these were considered in that judgment.
Yes, all of it. I don't want to... I just wanted to clear the text so that is absolutely clear and there's no question about it. May I move on with the date sheet?
Yes.
Kindly just come back to my page 2. Go back to 11/2/99, the first one. First date. 11/2/99. At page 2.
Date chart.
In note,
yes.
My note of submission.
C.
Flag C.
Flag C.
Your Lordships have that?
Yeah.
Just note here, now that I've shown you, grant order statutory under section 4.
Yes, 4(1).
Yes. Just, you could make a side note for my Lord's convenience since your Lordship asked me that query. I thought I can. And serial number 3, mining lease. Your Lordship could put Rule 31 Form K of the mineral concession rules. Just so that that issue is noted in my Lord's date sheet.
Yes.
Now, my Lord, kindly come to serial number 4, the central theme and document. 22/9/2004, MOEF granted EC to the erstwhile lessees for enhanced production of 4 MTPA, which was valid for 20 years and was co-terminus with the mining lease dated 14th August 2001 up to 13th August 2021. That is the period. 134. Sorry, I showed my Lords the EC itself, which my Lords have marked. The 2004 EC is not given at page 139 to 158, and the relevant part, 140. Yes, 140, specific condition A. Serial number 5, 29th October 2010, bracket 2008 EC. So, my Lord, for convenience, I'll call it 2004 EC and 2000
Flag C. Yes.
May I?
Yes.
2008 EC. The MOEF granted the EC to the petitioner for enhancing the production of iron ore from 4 MTPA to 15 MTPA. The said EC was subject to the petitioner obtaining a forest clearance, page 161. So kindly call this conditional EC. It could only spring to life when you get a forest clearance, which the CC and the MOEF said was not given in the two communications which I showed. So it never sprung to life. It was dormant, if I may use that word. Now come to 31/3/2014.
Probably enhanced 15 MTP.
Yes, my lord. Because it never
Not
happened.
4.
4 I am covered by my 2000.
Right.
Yes, exactly. I'm grateful. Precisely. Exactly. Now please have serial number 6, 31/3/2014, the impugned suspending letter. Respondent arbitrarily suspended the mining operations of the petitioner.
Which respondent?
This would be number 3, I think, my lord. R3.
Who is the authority to, has he got authority to suspend?
Respondent number 3 is right on top of the note is that Deputy Director Mines Joda.
How, which, where power?
Yes, I'm going to show. Just
that question will be to the other side.
Yes, yes.
But just we want to know.
Yes. Just kindly have the first sheet of the note.
First sheet of the note.
Yes.
First page.
Lord, Your Lordship, just for a minute, has the array of parties. First.
No, that we go by your version. We're asking you a pure question of law.
Yes.
See how competence to suspend.
Yes, correct. Lord, just only note, it is the Deputy Director Mines Joda Circle, who is the respondent number 3. Let's just have the document for a minute, my lord. If my lords could kindly come to 169.
Rule.
No, 169.
Page 169.
Yes.
He does not refer to any particular rules there.
Yes, but my lord, I just presumptively I'm saying that the power of termination and suspension is like an intermediate termination is always prescribed under the lease and the rules. I'll just show that. So at the moment, I am assailing the wrongful exercise of power.
No, you just for our in.
I'm
you have to read the matter.
Yes.
Although this question will be to the
Yes, yes. I just,
AG.
I'll take it out.
Yes.
Straight
Can you
away.
intervene on our request?
Very Miller.
Can you intervene on our request? Because the senior concern is on feet. We are asking you whether the Deputy Director of Mining,
Yes.
Mines and Geology, something like that. Response number 3. Does he have power to suspend the lease?
Deputy Director of Lease will not raise an authority under the Act. No, that is from the, has he completed? I'll answer.
This court wants to know.
Can't the court know? Yes, my lord, he is a designated authority.
Which is the rule?
My lord, in your lordship में
It is.
Just for our reference, to complete our idea.
Which is the order which is referring to the Deputy Director suspension.
That order is 9 dated 31/3/2004. That annexure 9 to the petitions, page is 169. It does not refer to any of the rules. Therefore, we are asking.
Let me just.
Reference may not be required, but we want to know what power he has got, whether he has got power. Then how power is exercised is another thing. That will be administrative law.
This is because this annexure 9, that is a suspension of the mining operation because of the expiry of the term on 31/3/14. So therefore, this Deputy Director is a designated authority.
Where is that?
No, but it may be by a notification of the government. Let me just read the MMDR. Or it may be the lease deed in the Form K which he has executed. Not one minute, see the bullet points.
There is one judgment from Karnataka. We have a minor mineral.
Give me 2 minutes.
Yeah. Whether ground of incompetence is taken.
No, that is not
No,
ground, Milord.
No, they might not have taken, but court can.
No, no,
right? Court can ask that
you
question.
can ask, I will
Yes.
clarify that, Milord. It must be, there is the competent authority, I'll just show. Direct to my school, this is the notification. These two check it out. Who is the competent? But give me some time. Let me just find out. There are 3-4 rules.
But can we do this? Let us move on and we'll both try and assist my four.
That's not in doubt.
Issue.
That is,
It is very much in our
mostly, yes. Milord, I'll answer that question. Give me some time.
In a way, the judges are like
Director also, Milord, includes the deputy director, or that authority must have been conferred by virtue of a notification by the government. Let me just check.
That is different from suspension.
not able to handle
It's not directly there. I've seen it is not there, but I don't know.
No, it is there. OMPTS rule. It is there. Or
It is not in this act. It can be in the state. So-
there is a jurisdiction in respect of the deputy director. Some circles are there, divisions.
Mr.
So
Acharya.
he is the designated authority. I am showing that.
Acharya, question as to the competence has to be answered not by argument, by showing. It's a pure question of.
No, I am showing from
By
the
showing
government
the-
notification.
We are only saying what someone says in the jurisprudence. Says. A question to which answer has to be found by turning the pages of a statute is a pure question of law. Someone says this in 12th edition, Federal edition. Question of law, question of fact. We are asking you.
No, that's correct. It's
That's
a question whether he is the authority competent under
Competent.
law to pass. such
Whether
an
he
order.
has got competence or not.
That's correct.
Turn the
That I-
pages and
that-
answer the question.
That's correct. I'm answering that. You let simply.
Very clear. Who is the authority? The committee could be formed today. So who the coach will be so the Mogola the coach. Then I will say, as the coach, submit to the
But we can. Yes, yes. It goes to the root of it.
It goes to the root of the matter.
Correct.
It will save our time.
Yes, absolutely.
Maybe your time also.
Yes, absolutely. Your lordship may take
With
it.
on that point, we can.
Yes, your lordship may
Tell me.
Your lordship may take it from me. In the lease, which is statutory, which I've shown, there is no such provision of power to suspend. And two,
They will take contention in the petition.
no, I have not taken up that contention expressly. I have assailed the order, but I have not assailed the order on this one.
These are
But that's a pure.
We only say, these
Yes.
are all administrative law.
Yes, correct.
The first order.
Correct. Fortunately, I'm not the draftsman. Otherwise, as your lordships know, that these are the first 10 points that we take are almost cut, copy, paste in all writs. But so I can only articulate, but
Your friend wants to assist you.
The things here, it should be 2016. It is not that is put in a last reduction is one remains center. And they go over thing. They go on this authority. And she would have been just be like, yeah.
now
Power to grant under section 21 of General Clauses Act.
yes,
Includes power to suspend.
yes, I will exactly.
In that light of that, we just asked this.
Yes, I know. And as an officer of the court to assist you, is the same person who issues the resumption order.
That makes no sense.
No. I'm only saying
that makes, with due respect, that makes no sense because whether he has got power to suspend or not.
Yes.
Subsequently, he makes so many orders. Therefore, he will have no answer.
No. I was only
answer that question.
Yes. My answer, my tentative answer straight away is under the lease agreement, which governs the particular subject matter which is before the court, there is no power that this R3 has to suspend.
No, the power need not. That is no answer. Answer is wrong. Power to rescind a statutory lease has to emanate from the statute itself. That is the law.
That's step 2. And step two, there is no such power under the MMDR Act, which authorizes R3 to do it. So it's a twofold answer, contractual and statutory. Under the mining act.
Mining lease.
Yes.
Deputy director is a party.
Yes. It's signed by the collector. I think I'll just show them.
Your question will not be your answer.
Collector, page 137.
Is he a party?
137. Collector is saying no.
Then your answer is not. That is what.
Executed by the collector.
Therefore, he is not the person.
He is not the person.
He is miles away from the lease.
Correct. Miles and hectares. Now, kindly just go back. So 169 I've done, serial number 6.
So we will not examine this subject matter.
No. I'm saying, my tentative response to my lords is under the...
not tentative. We can't write a tentative.
No. I'm saying while they're further examining it. Okay, let me rephrase it. Under the statute and the lease, R3 has no power to suspend the lease.
That contention you are not taken, but just
I was responding to a query of the court as my lord asked me, and I've also said that it's not been taken in that form in the written petition. Yes. Now, my lord, kindly the next page.
Mr. Acharya,
Yes.
can we make a request to you? In matters like this, one small error which we may commit because correct answers are not given at the bar,
Right.
may lead to a train of problems to the state or to the prospective minors also. Why can't you have
No, I'm answering. I got it. I'm sorry.
the
I got
department?
it. Let's say me holding the MMDR Act, there is a delegation of section 26. That I'm reading it. This central government may by notification in the Gazette. Therefore, I was submitting that there may be notification. I have already called for from the Steel Mine Secretary. Direct that any power exercisable by or under this act may, in relation to such matters and subject to such conditions, if any, as may be specified in the notification, be exercisable also by such officer or authority related to the central government, B, such state government or such officer or authority subordinate to a state government. So the state government, subsection 2 of section 26, may by notification in the official gazette direct that any power exercisable by it under this act may...
The same duplication of that section.
So it is already there. Only thing the notification. It is there, my lord. It is all orders are being passed by the deputy. That is not the, neither any ground is there, nor, my lord, that is in dispute. I will produce the notification. Gazette. I have already called for it. And deputy director is the authority in the respective division, my lord. Joda is a circle, Budville is a circle, Koira is a circle, Shodaukela is a circle, Jaspur
so many circles, but that's answer unless the notification is seen by us.
It is there now. We will. It is also, my lord, in the state rule that power is there.
Yes.
This is the Minerals Prevention of Theft, Smuggling and Illegal Mining
and regulation of possession, storage, trading and transportation, etc. rules, my lord, competent authority has also been done. So that is, my lord, means officer has mentioned in Schedule 1 appended to these rules. So Schedule 1, if
But
you
that Annex 9 is not relatable to that power.
No, it is there. It is notification. I'll produce, my lord, the Gazette notification. No, it is there, my lord, because it is a part of that. This, my lord,
it is
prevention of smuggling, illegal mining also, my lord. If somebody, my lord, there is a mining after
It is not
expiry-
on the ground, Mr. Acharya, because of Mohinder Singh Gill. Not what all you are arguing. We have to consider the order.
My lord, I
For the text
let
itself.
him complete his argument. Whatever query.
But we wanted to know the answer. But anyway,
I'll answer, my lord, every point. It was already, my lord, argued and the judgment was resolved. So it has been released subsequently before Chief Justice checked the discrepancy. It has again come. So his lordship, my lord, before retirement, I think Justice Ratha refused, Savitri Rath. So it has come.
matter was heard.
Matter was heard and judgment was reserved for 2 months. Thereafter, it has come before your lordship. And 2 such writ petitions, my lord, with identical prayer, they have been dismissed by 2 different division benches of this court, including one. Santipriya Minerals case from Karnataka.
Will come.
Justice Puka just. I'll cite it.
Either you have it after
Nothing
that, you can
remains to be
research the
decided.
point and assist, or I can continue whatever.
Continue. No, it's another 15 minutes.
Yes. So, my lord,
Why we asked that day?
I agree.
If that point is made clear that he has no power,
Story over.
then the rest of the things we need not undertake. We can save lots of time. Otherwise, many of the lawyers have to wait.
So
you, for the benefit of.
So, your lordship, we call it after lunch. I will come back with the authoritative answer that we save time. I also understand that other people.
That is a important matter for me. Some other day, if you.
The rest of PA, there is a Supreme Court remand
Let me
matter.
try and complete.
So I have to be there.
Just start.
Yes.
It's also a mining matter at 2 p.m.
Yes.
It's a remand.
Yes. So, my lord, I am on 31/3/2014. Kindly have page 169.
Yeah. We have read 169 twice now.
Yes, sorry. So, my lord,
Next
this
point.
Yes. So, why is this wrong? Threefold answer. Just note only because I've already shown it. First, page 249.
Go to 249.
6.
At 248 is the report of the Central Empowered Committee submitted to the Supreme Court.
That the para 147.
Yes, para 147. So, first error of the suspension order
6.
is 249 para 147. So they validate the fact that the condition was there and that is not been. Second is evident from page 253. I've already shown you MOF letter. Not serial number 10 of the date sheet. Your lordship can just note it. Serial number date sheet.
Go to C.
15/1/2015, page 253. My lord has that.
15.
So in this date sheet that I give,
What January 2015.
correct.
Yes.
At page 253 is the author, the Ministry of Environment, Forests and Climate Change, itself says that forest clearance is yet to be accorded. Paragraph 1, last 2 lines. The EC was issued for 15 MPA subject to the forest clearance, which is yet to be accorded. And this is of 15. So even the position remains what I said, 2004 valid, subsisting in force, 2008 did not spring to life, it was conditional. And the author, as your lordship knows, the Supreme Court says greatest weightage is attached to the author. He himself says the EC has not yet been accorded. Forest clearance has not yet been accorded. Right, my lord? He then makes this subject to the orders of the Supreme Court, which I showed, my lord, were passed on 5th 2020 at page 291, which my lords have already noted, so I'm not going to labor on the point again.
Yeah.
So for these 3 reasons, the impugned communication of wrongful suspension is completely illegal, unsustainable, and contrary to the material on record apart from the query which my lords have put, if I can show that there is no power to suspend, then as you said, like a house of cards, it all falls. Now, my lord, I have therefore, what is the consequence of this? That is on the very first page, my lord, if my lord could have about in the important timelines. Roman capital 3 important timelines, subclause small 4.
1/4/2014
Yes.
to 31/1/2020.
Correct. This is 5 years and 10 months. Now, my lord, at 134, may I just request the court once more to come back to that clause 4 of part 9.
If there is any culpability on the part, any lapse on the part of the lessor,
correct,
then that period needs to be added.
To add it back. So, my lord, this is the point. Now, my lord, please have.
You may not repeat because we remember.
Yes. So this really, my lord, captures my entire case in a nutshell. Now, my lord, also filed additional written submission on 23/12/2014. Just for completeness for the court. And now my lords will note a few points, my lord, which are important, which your lordship will hear. Two judgments of the court, my lord. It's in the compilation. G, flag G. Lord Gujarat, Lord Dharamveer versus Union of India.
Dharamveer versus Union of India. What is the proposition?
Yes, Lord, see this. You can add it back to court recognized. So, sorry, one very important point. Kindly just have page 26 of the writ for a minute. Lord, kindly just have page 26. Sorry, one
of the petition.
Yes, one last point on this.
Go to page 26
of the writ.
Without understanding it to answer, or they are saying that
we are at page 26.
Yes, Lord, kindly have just
N, which
yes, N. Yes. Lord, kindly see this clause which I showed at 134, mirror image in the rules. 12(1) FF of Mineral Consensual Rules 2016.
So that force majeure clause.
Yes.
Where is force majeure here?
No. I'm just saying the same language. The lapse.
Force majeure is interpreted by.
No, I'm not. I'm on the lapse. I'm on the lapse.
Lapse is not force majeure.
Yes. Lapse. Very well. We'll skip this. So, Lord, this is the point. Now, let me show a judgment called Dharamveer versus Union of India. It's in the case law compilation.
Which paragraph?
Yes, you not kindly have para 43 and 43 and 44. May I read, my lord?
No, sure. But it again is on the force
majeure. Just leave the line after that. Though this is not a case of force majeure. In terms of analogous principles, it appears to us, this is the word I'm relying on, that the unlawful interruption and cause to the lease by the illegal act of the respondent is something the lessee could not reasonably prevent or control.
Who was respondent number 2 there?
Respondent, state again. Unit.
No, there are two aspects.
Yes.
Under the law of Legislative Mukherjee.
Yes.
If lessor comes in the way of enjoying the leasehold, then remedy is elsewhere. If some XYZ comes,
yes,
then remedy is elsewhere.
Yes.
Therefore, we are asking you.
Yes.
Who is response number 2 in this case?
Yes.
In that case.
Lord, this is also kindly have advocated it. It's Haryana, I think, if I'm not mistaken. I'll just show you. Lord, I think it's Haryana. Just give me 1 second. Yes, Lord, kindly have page 22.
Of
The same Dharamveer judgment, the page 2 of the compilation. Mary, just under the author's name, Leela said, in this writ petition, the petitioner is challenging the order of the government of Haryana terminating the mining lease. Granted to her. Now kindly come back to page 35, para 43, which I was reading. I'll just read it again. Though this is not a case of force measure in terms of, just this word I'm emphasizing, not very importantly, and the period of this interruption should be excluded from the term of the 3-year lease. It appears to us necessary as a matter of law and justice to give the
multiplicity of litigations.
Yes, correct. So, my lord, this is a direct judgment, my lord, on the point that where there is an unlawful interruption, as in this case through the Impugned Act, that added back should come back. So this is, my lord, a direct judgment in our favor. Now, my lord, I just need to clarify 1 or 2 other aspects. Lord, kindly just have the next judgment, Avtar Singh versus Union of India, serial number 4.
Yes, page 38.
Sorry?
Page 38. 93 Delhi. 1993 Delhi.
Yes, yes, my lord.
What was the question? How it is answered?
Yes. Lord, kindly just have the kindly have, my lord, page 38.
Is 38?
Yes.
What that was under mining matter?
Yes.
Yeah. Where is the relevant paragraph?
Yes, not page 38. Yes. My lord, the petitioner was granted a lease for a period of 10 years. My lord has that?
Correct.
Para 2.
Effective from 87.
Yes, effective so and so. And the line on top says cancellation of lease. Para 5 notes it's terminated. Page 40, para 5. My lord has it? Para 5?
Yes.
And consequently, yes, in exercise, state government terminate. We are not on that yet. And the operative part, my lord, is para 75. Page 60.
In the light of?
Yes, in the light of what is discussed above, the petition is allowed, the impugned order of termination is set aside, quashed, writ of mandamus is issued to restore possession of the petitioner immediately, and it is directed that the period of unlawful interruption shall be excluded in computing 10 years from the lease granted to the petitioner.
Yes.
And just para 70 also, my lord, at the same page, applying all the judgments, I am of the opinion that the petitioner shall be entitled to be restored possession of the lease granted to him and shall be entitled to exclusion of the period of unlawful interruption in computing the 10-year term of the lease. So, my lord, these 2 judgments with great respect and humility, the ratio of these judgments squarely applied to my case, where whenever there was an unlawful interruption, the court has granted a writ of mandamus, restoring, my lord, my lawful rights which were curtailed. Now, my lord, I just
Delhi matter was not taken to apex court.
We checked. It has not gone to apex court. No. I'm saying that on instructions. So, my lord, these two judges.
See that whether it went to apex court.
I think it's just whether it went to DB or apex court, just see. You want the citation? Yes, give the citation.
Any other high courts in the country have referred to this Delhi judgment?
I'll examine it. Now, my lord, I need to clarify one or two things which your lordship may. Lord, please have page number 8 of the writ petition. I'll just state the point for the court and then show. Lord, my grant order was for 20 plus 10, 30 years, which I showed. The present writ petition is confined to adding back to this 20-year period.
5 years, 10 months.
5 years, 10 months. There is a separate limb and leg, my lord, which is on that 10 years, which I have not got. I have expressly said here, my lord, kindly have page 8, small f.
Yes, acting upon.
Yes, but if your lordship just kindly comes back to in the middle of page, it is important to mention. It is important to
regarding the
execution of 10 years mining lease is pending consideration before the Supreme Court, and the petitioners are only agitating the issue regarding lost 5 years and 10 months of the mining operations.
The 10 years is 20 plus 10.
Yes,
that 10.
Yes, I'm not
You
on
are
that.
concerned with that.
Yes, and my lord,
This is not a question of add-on at all.
Exactly.
It is like a compensatory period.
In terms of tenure, and my lord, at page 18 of the same writ,
yes.
But in that other writ petition, which is now pending in Supreme Court by an order of this court, I have expressly reserved my right, which I have extracted para 32 from that writ petition at page 18. The highlighted part. The petition.
No, that question may not arise because it is being examined by the apex court.
I am saying this because your lordship will
should
hear.
not,
will
why
hear.
did it-
So I should point out as an officer of the court what my case is and what my case is not. So I am only doing it from that point of view. So I have made a clear demarcation, separation, and full disclosure in both courts. Right? Now, my lord, there are two other judgments that they have on in their counter called Ramesh Prasad Sau and JDL Limestone. Your lordship may just note in both cases, the lessee gave a waiver in a supplementary agreement that he will not
claim that.
Correct. Exactly. So that doesn't apply because there is an express waiver stroke acquiescence in that case.
Which is conspicuously absent in 1967 and in Delhi.
Yes, I'm grateful. Exactly. So my case, if I may use the word, the Kundali and the DNA is to be matched with the two Delhi judgments which I cited for the court consideration and not these two.
Judgment. Two Delhi judgments. One Delhi judgment.
One and the other.
One Delhi.
There is apex court.
Yes. Sorry, one Delhi judgment. Right? So this is one of the main issues which they had raised. I've segregated that issue. Rate I have already answered. Why rate? Because my substantial right has been impaired. So kindly now have my relief in the petition. Page 33 of the writ.
Please face.
Page 33. Issue a writ of mandamus or direction to the opposite parties to consequently add that 5-year, 10-month period which was lost due to the wrongful closure of the terms of clause 4 part 9 of the lease deed dated 14th August 2001, that is page 134, initial 20th. This is very important again.
So the 20 plus 10. Because of that you are saying
yes,
that initial.
I'm just saying initial. I made that clear segregation and demarcation consistently. And therefore, consequently, to undertake mining operations over this area for 5 years, 10 months. Act in the other case, the court gave a consequential direction to be restored.
As apex court.
Yes, put it back in possession and do it. So I conclude by saying, that impugned order is legally unsustainable. It is illegal. It is contrary to the record of the case. It is contrary to the CEC report set up by the Supreme Court. It is contrary to the MOEF communication expressly saying that 2008.
Any return submissions are filed in this matter?
Yes, this what my lord called flag C.
Flag C is a.
Yes, Lord, I have my submissions also. Just kindly turn over the screen. It's at page 5. Page 5 of that flag C. My lord has that?
Yes.
Your lordship will see submissions. It's like this, my lord, in chart form I have done.
Yes.
Instead of reading it, I have. So can I just quickly do a tick the box since I have few minutes before lunch?
No, we're doing that.
All right. So my lord, first point. Can I just do it with the court with your permission?
May not be necessary.
So my lord, your lordship will see I have the issue and my answer to all the points. Second is very important at page 6. That my statutory and contractual right was lost.
Yeah.
And in addition, as I told you, my lord, I filed additional written submissions on 23/12/2024.
That is clarification we need. You
Sir?
say the provisions of law relating to leases.
Yes.
Incorporated in Transfer of Property Act are not applicable to this.
Yes.
Are you supported by any decision that you have?
No, my lord, because I've shown that the wrongful suspension is contrary to the record.
That's beyond that. Even under lease,
Yeah,
under
I
that act.
will check, but it's a self-contained statute. Your lordship has impugned action in the fourth.
That we do.
Yes.
But just we wanted to.
I'll check that also.
Because there are judgments.
Yes.
Which
No, that may not apply to mining cases.
Pollock and Mullah,
Yes.
they have said in one world edition.
Yes.
During my student day,
Yes.
they have said the Transfer of Property Act applies to transfers property by way of mortgage or lease also
Of
if
land.
they are brought about pursuant to statutes.
But with greatest of respect, Supreme Court has also shown MMDR Act is a self-contained code, and this is about mining rights. Those may be applicable land. So there will be a difference. A specific statute will always not with greater respect prevail over.
And leases are divided by MMDR.
And yes, and without this, yes, and without there's one Sandur Manganese judgment of the Supreme Court which says MMDR Act and the MC rules constitute a in the matter. So when there is a specific enactment, a specific statute, the lease is issued under that statute. My rights flow from the grant order read with the mining lease.
So you need not travel.
We don't have to travel outside that.
Transfer of Property
Yes,
Act.
the boundary will be, if I may use the word, this. Not the mining boundary, but the legal boundary will be here. So this with greatest of respect is my case, and therefore I'm asking for those two reliefs to be given in light of the two judgments.
Who will answer the question we can?
No, of course we will.
But
The burden and the responsibility is on me.
Begin for 7-8 minutes, I think would be sufficient enough, not to highlight on the case. Three broader negligence that you will achieve. There cannot be a relief against the statute, number one. Number two, the present petition is hid by the principles of res judicata. In an earlier read petition of 2021, there was a prayer for extension of the lease period beyond the term of expiry, that is on 13th of August 2021, which has been rejected by this Hon'Ble Court, and the matter is pending before the Supreme Court by the other side.
It is extension for 10 years.
Whatever, Milord, the finding I will read out. Milord, should I read one paragraph?
Yes, read.
Milord, that was rejected by the government. That was one of the prayers. Extension of 10. Milord, the statute says there cannot be any extension or renewal beyond the period of 50 years or till the expiry of 31/3/2020.
Where is extension?
section, your lordship may kindly turn to section 8 of the.
No, where is he asking for extension?
No, he is asking for a period for which he says allegedly, that amounts to the extension of the lease period beyond 31/3/2020, which is not permissible. I am explaining, my lord, one by one. My lord, the prayer in the writ petition is to permit him to operate for a period for which he did not have the statutory clearance, or for some reason or other, he could not be able to operate the mines. That is the short question. This particular question has been raised in 2 writ petitions before this Honorable Court, RP Sao and JDL Mines. So also before the Honorable Karnataka High Court in Santipriya Minerals. And so far JDL and RP Sao is concerned, that went up to Supreme Court.
What they said?
That there cannot be an extension.
Where is the extension?
Well, this, even that period of lapsation cannot also be granted. Even if, yes, Pillar, that is the judgment I'll place one by one. I'll come to that. Let me.
No, if you
Pillar, should I go serially? Let your lordship see the statute first.
Yes.
Pillar, your lordship knows earlier, there was 30 years, then first renewal, second renewal, like this, my lord, for indefinite period, minors were enjoying the leasehold rights. It's a resource. So, my lord, the union government thought it prudent that for a specified period, beyond that, 31/3/2020 is the cutoff date, there cannot be any leasehold right in respect of any mineral. So it was put to auction regime. So this particular lessee, my lord, has been enjoying that particular, not of course now, since August 2021, the lease period has already expired. He has operated the lease for more than 60 years. 50 years is the capping. So, my lord, after the insertion of the 2015 amendment in the statute, if you will submit me, I will place these statutory provisions, whether such a relief on the teeth of the provisions contained in section 8A, capital A, subsection 6 can be granted to the petitioner at all.
Yeah.
And that question has also been considered in the earlier Sarda Mines writ petition by Chief Justice Muralidhar, which is pending. The incidentally, my lord, that is the question, whether it can be done beyond the expiry of 13/8/2021. That is the question. Your lordship may kindly turn to section 8 of the Act.
MMDR Act.
MMDR Act. Lord, 5, 6 sections I will place. That the full object, your lordship knows that there should be equitable distribution of the natural resources. Lord, to translate Article 39 into reality, it should not be concentrated in a fewer hands. So to translate that object, the Union Parliament in its prudence, my lord, came out with this provision in 2015, effective from 12th of January. Period of grant of a mining lease for minerals other than coal, lignite and minerals. The provisions of this section shall apply to all minerals other than those specified in Part A and Part B of the first schedule, on and from the date of commencement of the mines.
This lease falls under which Part A, Part B refers to what?
Says, I don't know, my lord. Sir, I don't know. That is not, it is governed by 8A. That is not the, it is, I don't know.
Part A, Part B.
A is Part A, my lord.
This is Part
I
A.
don't know, it is Part A.
Part A. Then
Part A.
The provisions of this shall apply to minerals other than Part A. How this you are applying this
Provisions shall apply to minerals other than those in Part A and Part B of the first schedule.
This is Part A.
Number part in those specified shall apply to minerals
Other than. If falls into the
I don't know,
than.
Pilot, Part A or Part B. I do not.
He is Part A. I am iron ore.
No, that is not the. That is not the Part A.
Yes.
Just a minute. Iron ore is governed by this pillar, section 80.
Section itself says Part A is not applicable to this.
No, part A is hydrocarbon energy minerals, coal and lignite. Part B is atomic minerals. Part C, pillar you are stripping.
Iron?
Iron is
Part
pillar.
A and B of the schedule.
Yes. Let us see pillar.
Iron falls into which?
C is pillar.
C number.
Part C number 6.
Then he's right. Why you say Part A?
Sorry. Part
Yeah.
Mr. Jain is good at misleading at times. So I got confused also, you know. On and from
we
the,
do not
no, I was
we do not,
learning the flow. So
take
on
us to
and
the
from the
last
date of commencement of the Mines and Minerals Amendment Act 2015, all mining leases shall be granted for a period of 50 years. This is important. On and from the date of commencement of the Mines and Minerals Development Amendment Act, all mining leases shall be granted for the period of, this is the maximum period, shall be granted for 50 years. All mining leases granted before the commencement of the mines and minerals shall be deemed to have been granted for a period of 50 years. 2, 3, your lordship may look at the language. On the expiry of the lease period, the lease shall be put up for auction as per the procedure specified in this act, provided that nothing contained in this section shall prevent the state government from taking an advance. TK, please don't murmur. I am getting disturbed with an advance action for auction of the mining lease before the expiry of the lease period. Principally, we are concerned.
How we are concerned with this section?
No,
This section, I have read that. This section.
no,
says-
six milord is important. Your lordship may say.
Six.
Six.
Huh.
Notwithstanding,
2, 3, 4.
included in 2, 3, and 4. The period of lease granted before the date of commencement of the Mines and Mineral Amendment Act 2015, where mineral is used for other than captive purpose, shall be extended and be deemed to have been extended up to a period ending on the 31st of March 2020, with effect from the date of expiry of the period of renewal last made, or till the completion of renewal period, if any, or a period of 50 years from the date of grant of such lease, whichever is latter, subject to the condition that all the terms and conditions of the lease have been complied with. So, relying upon this subsection 6 of A, Milord, 2 judgments have come from this court.
No, how it's applicable? Mr. Acharya, this section 8A contemplates the period of lease shall be 50 years.
Correct.
This shall not be applicable to A and B of the schedule.
Correct.
Wherever leases are granted for a period short of 50 years shall be deemed to be 50 years.
Correct.
And clause 6 is an exception in the proviso to the other above provision.
Absolutely
The
correct.
extension.
Where is the?
Extension of the lease.
I'm not
There
getting
is
your
lot of extension of the
No,
lease at
Milord,
all.
extension period of it cannot be more than 50 years, Milord.
Correct.
Cannot be more than 50 years.
Correct.
Whatever.
Correct.
Period capping is 50 years.
Correct.
It is a lease from 1934.
Yeah?
The 34, Milord, 1934. They have operated it for more than 60 years.
Yes.
So beyond 31/3/2020, there is no mineral right. Not only High Court, Milord, in common cause also, the Supreme Court has clarified this. I will refer to judgments, Milord. It is already settled. There is no gray area in this. There is no mineral right. Milord, I repeat, on a conjoint reading of 2, 3, and 6. It has been interpreted, Milord, in 3 judgments, which I have filed in the counter affidavit also. I'll place it. Also one from your Lordship's Karnataka High Court Justice Poka judgment.
No,
I'll place
it is my court now.
No, that's correct. No. I am conscious of it. Not every high court is a high court. So, but there are 2 earlier judgments which have already attained finality in Supreme. So also this particular petitioner, Milord, I'll place that earlier judgment.
This fact was not.
That has also been.
It has been started since.
There is no mineral right beyond 31/3/2020. That is the date. Your Lordship, I am reading it, Milord. The period is 31/3/2020. It is written here in subsection 6, Milord, up to a period ending on 31st March 2020. Accordingly, all the leases, my lord, have been put to auction. All the leases all over the country. Not that it's a solitary case which is to be singled out and is to be in a different manner. It has already been settled. 31/3/20. My lord, may I read it again? I don't think it has been interpreted.
No,
It's a non-obstant
why you have conceived this? Because the whole submission has been made as if the lease has been initiated in the year 2001.
No, since 1933, my lord. He has operated for more than 60 years.
Yes.
He claims that for certain period.
This lease is for what period?
Which one, my lord?
The lease now, which is the subject matter.
Since 1934, my lord, he is operating.
Be operating right from 1526,
Right.
when Babur came here. That's not the question.
Right.
The question, the petition relates to which lease?
This particular Sarda Thakurani mines, my lord.
No. Lease. Lease deed.
Lease is defined. We are
Lord,
asking
your
you,
lordship,
this petition.
It is a lease of 1934 for Thakurani mines area. Original lease deed is of 1934. There is, my lord, extension period. Earlier, your lordship, it was for 30 years. Then first renewal is for 20 years. Then the renewal is for 20 years. So, my lord, the last renewal was made in 2001 and the period of 20 years expired on 13th of August 2021.
No,
so he is...
Mr. Acharya, just we want to know, because we do not much know about mining law.
On facts, your lordship should be clear first.
Therefore, we want to know.
So let me.
When this lease was granted.
This is the second renewal, my lord.
Is it a renewal or a special?
Renewal, no. It is a renewal. Renewal is for a period of what? For a period of 3 years. So, 3 years. That period, my lord, expired on 13/8/2021. Does you got it, my lord?
No, we have not got it. This lease, show the lease deed.
That's correct. The last
Show the
renewal,
lease deed.
last renewal at page 96, my lord.
Page 95.
96, my lord. Annexure 6. No, let two things be clear, my lord. I'm not. Lord, one thing, let me make clear. There is no right, mineral right, beyond the provisions of the statute. Number one, it's a settled law. So many judgments from Rungta till now.
Yeah.
Second thing, statute prescribes a date beyond which no renewal can be made. Maximum period of lease granted to a lessee would be 50 years, not beyond that.
Kindly come to, just for our understanding.
So,
kindly come to page 97.
97, got it, my lord.
96,
90. Yes, period of lease. No, it's, yes. Period from 14/8/001 to 13/8/2021.
Go to model form of mining lease under C, Rule 31. Let us see the model form.
Form K, my lord. This is the Form K.
Yes.
This lease deed itself is the model form, in which this is, my lord, page 97.
That relates to Rule 31.
Yes, Form K.
Rule 31.
Rule 31, my lord. This is the Form K. The entire annexed is Form K. And verbatim it has been produced. Form K, my lord. Under the new rule, my lord, earlier it was 1960 rule. Now it is 2016 rule after the amendment.
Which rule we should see now?
So now 60, my lord, Form K, because the amendment came into force from 2015.
Yeah.
So this particular renewal did last renewal, my lord, the second renewal was executed in 2001.
Under the old rule.
Under the old rule.
Old rule. Do you have the copies of old rule?
Yes, it is in the book itself, my lord.
In this book only?
Yes.
Yeah.
MMDR Act. At page 125, if a lordship is holding this book, professional, My Lord, Justice Das, Your Lordship would,
Yes.
Your Lordship would find the firm K as 125 of the above. The same thing, my Lord, is annexed 6. So instead of referring to this,
Whether these rules differentiate between grant of lease and renewal of lease?
yes, of course, my Lord, it is there in the statute itself. Your Lordship would turn to Rule 21, my Lord.
Series. Kindly come to 31(2).
1:2. This book is very confusing. So many.
The old rule, 1960 rules. The date of the commencement of the period for which a mining lease is granted shall be the date on which a duly executed deed under sub-rule 1 is registered.
Right.
So sub-rule 1 is registered on which day?
That is below that date. That was not.
That is in
14th August 2001.
2001. Are you taking us back to the pre-independence era?
No, my Lord, that is the second renewal. Lordship is your
This rule says lease period will commence from the date on which the deed is executed. This gives an impression, regardless of what nomenclature you put to the lease deed on its forehead, the statute says when the lease is deed to the.
No, that is correct, my Lord. Your Lordship may kindly turn to 24 capital A.
Will you
It's
allow
in
us to
respect
eat
of
our...
the same lease of pre-independence. I am not taking your Lordship. It is in respect of the same leasehold area.
Correct.
Thakurani mines, in respect of which first, second renewal has been granted. Your Lordship have to keep that in mind.
Where is the...
Not that it is a separate.
We are asking, where is the renewal clause? Just show us.
24A, my Lord.
24A.
An application for the renewal of a mining lease shall be made to the state government in firm J at least 24 months before the date on which the lease is due to expire through such officer or authority as the state government may
Form
specify.
J. Form J.
Form J.
Had they applied under Form J?
Of course, my Lord, otherwise this renewal cannot be granted.
Mr. Jain.
Yes, provided that it is right. Form J says that
Format will be clear. This is application is in J. Under which your application, is it a case of renewal of lease or a fresh lease?
this renewal, my Lord, that is not on fact. my Lord.
What I
Yes.
said,
14th August 2001 is the renewal.
renewal.
Yes, but these
It's a
facts are
renewal
not,
of-
I'll give a fact sheet, my Lord.
Yes, yes.
There is not, my Lord, let us not go. It is a pure question of law, whether he has a right after beyond 31,320. That is the very plain and simple question. If your Lordship would ask me, then I'll go factually one by one.
Mr. Acharya
Yes.
is born after eating Amrita. He does not require anything at all. But for mortals like us, we have to go back and
Your Lordship is correct. So it said second renewal, my Lord. So the period was initially for 30 years, from 34 to 64, then from 64 to 74, then from 74 to, I think the third renewal. So he has already operated the mines area, this particular, since the pre-independence period. Your Lordship is absolutely right. 1934. So 2020, my Lord, was the last capping date, but the statute says beyond 31 it is 50 years or 31/3/2020. So 50 years period have long since expired. So what he is essentially is praying to permit him to operate for the period for which he was, my Lord, statutorily debarred from operating because of certain lapses, environmental, forest, that is not automatic, my lord. It is subject to obtaining the necessary statutory clearances. So what he earlier in petition, my lord, he was asking for another 10 years period of renewal. Essentially, the prayer is the same. My lord, may I read only one paragraph?
That's not our subject matter.
No, that is correct. No, that is, my lord, very much is the subject part.
No,
that it has not been
10-year matter is before the apex court now.
No. Maybe, but it was before this court, my lord.
No,
He was
court.
claiming for 10 years. 10 years, you'll have to pay kindly.
Acharya, after 20 plus 10 it is.
My lord, that is correct.
Back then he is being litigated before the highest court of the country. We have not seen the matter.
21 in the earlier petition of 1, when it expired, my lord, also relates to this period. We stated that beyond 31/3/2020 you have no right. That has been upheld by this court with a finding. My lord, may I read only one paragraph? Just a minute. Why I say it is res judicata, just your lordship, while answering that, whether he has any mineral right beyond 31/3/2020, my lord, it has been answered. My lord, judgment could be ये जजमेंट का बढ़ा हुआ टेका नेक्स्ट टाइम just give me. Milord, 2 paragraphs. I'm reading it, Milord.
Yeah.
The starting point for the present.
Can we come back? Can we come back?
2 p.m. another matter, Justice Sahu. There is also one mining matter which is
kindly tell Mr. Sahu that perhaps he is sitting in
it is targeted by the Justice Dipankar Datta's bench because there is also there the default at 2 p.m. Milord. He has fixed last occasion. Mr. Palit was also, the court is not granting time in a date to finish. And because the Supreme Court is hearing that common cause matter. If you lordship put tomorrow in the first hour.
Tomorrow.
Which matter? Tomorrow it would be better.
Yes.
Can it be after the your lordship finishes the first matter?
At 2 o'clock we'll have this matter.
Because tomorrow there is a reference. It can maximum your lordship can hear up to 3. It can be 12.
First 12. If your lordship could have it in the first half.
First half. 12.
Not 12 because the
2 to 3.
2 to 3.
12 to 1.
12 to 1, then 2 to 3. I'll continue for 2 hours.
Yes. You kindly complete, you bring your notes so that we can save our time. Your time can be saved. You are wanted, most wanted everywhere. We are not that sure.
I'll come with this fact may not be because it's
great.
What is the Lordship has directed us to file a note.
23.
23.
No,
This was yes. Yeah, Mr. Learned ASG is also there. Just
No.
Yeah.
I'll not. I'll give my regards also to Parija in the process, my lord.
I think we're him on this side, Milord. We are missing him on this side. It's time he comes back.
That perhaps will take long time. We will be disappointed.
One item.
A lot of pressure that side.
It's more than 1 minute. Lord, your lordship has directed us to file note. Lord, we are placing the note on record. We have filed the note. It's all from our end, my lord. Unless he wants to say.
A small question we wanted to ask you.
Yes.
If we are thinking aloud, that way you may just consider. Suppose if view is taken that suspension beyond the tenure of service cannot do. How you will be aggrieved? For rest of the things, all other things will follow.
We will be agreed this way. We have placed in the note 3 judgments of the Supreme Court where they say when on retirement master-servant relationship ends,
Yes.
But the jural relationship continues for pending cases. That's exactly what Supreme Court has said.
Correct. That's what we are saying is consistent with that only.
Yes, but may I put it?
How suspension can be continued? I also made some research. I could not place our hands on any one single judgment which says the suspension can be continued beyond the tenure of service. It spurns logic and the service jurisprudence.
But we have only one difficulty.
Yes.
Let's do the clarity in it. But the suspension will end with a retirement, no problem.
Correct.
Should not be restored with any benefits or any such thing, because the jural relationship of trial is going on. That's something very important. See, it makes to say that it will end and therefore everything will get restored, then we are actually beating the law.
No, we are not saying that. The challenge was suspension order. We say the quashment of the suspension order is correct. Rest of the things we will say will pain into insignificance and liberty is the result to proceed against the concerned employee. We are just thinking aloud. Don't be under impression that we are passing that order. We are putting this across to you. So that because I saw 3 books on that. One is Law of Suspension by Mishra. Another is Services under the State by Rama Joyce. Third is Law Relating to Public Service by Samaraditya Pal. Nowhere I got an indication that the suspension can overstay the retirement of an employee.
2 things we have found out. I think we are converging there. Not suspension may end on retirement, but the misconduct which is under examination.
That way.
Misconduct never goes that.
Yeah, misconduct cannot go like that.
So I think in fact we didn't raise any issue on that at all.
Yes. And the tribunal has not considered what he had argued actually. And what you had argued also. The tribunal took its own way away from the parameters of the pleadings. That was not his case at all. His challenge was to the suspension order. Since he has retired, the suspension order commits legal suicide. And for other things, it is open to you to proceed if the rules permit you. That is not put in challenge before us. Why all this argument?
Your Lordship should not say, don't regularize the suspension period. That's till retirement. If that is his case, that is something which we are opposing.
His case itself is for quashment of the suspension.
No, your Lordship need not quash it. Your Lordship can say,
Lord, I know what your Lordship rightly said. Initially, the OA was filed for quashing the suspension order.
Yes.
Later on, due to passage of time, he had retired. So I took an alternative pleading that because you have not passed any order. They also admit in their written notes that same thing.
No,
they said 54B will apply.
One suspension we are quashing not on the ground you urged when you were in the course of service.
Yes.
It commits legal suicide.
Yes.
Because you have demitted office or in the age of superannuation.
Lordship.
And for rest of the things, you make appropriate representation which they will consider in a time-bound way. We will not say on that.
Lordship,
the center, and the employer has to decide those things.
Lordship, whatever is there, I have a small compilation. I'll just give me 10 minutes time to play. I'm exactly following and I'm in line with Lordship's thought process. And if your Lordship will give me only 10 minutes time, I'll explain everything subject to correction. I have a judgment which actually favors them that we are talking about whether the second part of the would appear or not. I have a judgment which actually favors them is against me. I brought that also because as an officer of court,
may not be necessary. Question is not that we don't have 10 minutes. We have many minutes, hours. Is all. But a small matter which can be more than what is necessary, court should not undertake the examination.
Lordship.
The suspension will having come to an end by virtue of the respondent employee, the OP employee retiring on attaining the age of superannuation, matter is disposed of. if there is any grievance in relation to this order, under the shadow of this order, you should work out it after making an appropriate representation to the.
As far as I'm concerned, that duty.
No, that will not.
The charge sheet will remain. I'm not on the charge sheet part of it.
Charge sheet will remain.
That will remain. I'm not on that.
Because you are retired.
No, that
misconduct.
No, I'm not saying even that. That's what I wanted to place because that period has to be decided. They are themselves saying so.
You make
and your lordship judgment of 6th, 7th only covers that.
Correct. But you make a representation in the light of that judgment in a time-bound way. They will consider.
May I only submit one thing?
Yes.
The laws laid by Supreme Court, my lordship has followed on 7th is that if they don't pass an order within a reasonable period, they are denuded from passing an order. They were making a representation, all will be not in accordance with the law.
No.
Because it has to be treated on duty, the charge sheet may continue.
No, then we are deciding the legality or illegality of the order of suspension. That
the quashment of the suspension.
Yes.
During the tenure.
Yes.
We do not agree with that. There is a CBI inquiry.
Yes.
These things have happened.
Anyway, all that after retirement, your lordship.
Anyway,
all that
there
after
is a
retirement.
matter which merited looking into.
Yes, I come to
CBI.
then just give me 10 minutes, your lordship. Let me present my case, your lordship. May I hand over these rules and judgment?
I have instructions to say this, my lord.
Yes.
If your lordship says this.
Can you be little louder?
Yeah, I'm sorry, my lord. Am I audible now? Am I audible?
Yes.
If your lordships, my lord, I have the following instructions to say. If your lordship says suspension ends because of retirement, but the disciplinary proceedings and the CBA proceedings will continue, we have no problem. Your lordship will say that very clearly in the order.
That's the thing.
And no regularization, so fine, perfectly fine.
No regulation we did not say. We only said he will be able to, he should make a representation in that regard. Your client should consider it. Keeping in view the settled legal position.
Now, I think, may I put it this way? Lord, we are now dissecting two issues. Legally, on retirement suspension abates is one issue, no problem.
Correct.
But proceedings do not abate is also something we are.
That.
Therefore, Lord, your lordship may only say this. Proceedings, whether disciplinary or CBA, will continue as it is and leave it there, Lord, rather than saying anything that has to happen, let him do whatever he wants to do. That's all.
No, about disciplinary proceedings, we will not say one single word because the other matter is pending before the CAT. It is for the CAT contention. Treat that contention. We will say the suspension having abated on its own by virtue of the OP employee having demitted office on retirement on attaining the age of superannuation, much is not necessary to be examined. Ordered accordingly and petition is disposed of.
Rest of the Lord, your lordship may have to say rest of the issues, Lord, are not dealt with. Lordship may give up. This will all now for next till the cows return home.
Very well. Then we will say validity of disciplinary proceedings being determined by the CAT. We are not saving one word about that. All contentions of the parties are kept open. Yes. If because of suspension coming to an end on demitting the office, whatever rights that accrue to the employee, he should work out those rights by making a representation to you, which you will consider in a time-bound way. In that connection, all contentions will be kept open. Are you agreeable with this proposal?
I have instructions.
No problem, because then I know the government departments have worked there for 38 years. They'll reject it. I'll have to come back to the court. And he has not received a single penny as even retirement, not even provisional pension. So the question is, they themselves admit to what is falling from me and we may see their written notes of arguments, para 13 and 14. Their written notes of argument. What have they said?
I will make it one more time clear. If a friend wants to expand and nullify the disciplinary proceedings and CBA proceedings, please do not permit it.
No, he is not. Mr. ASG, he is not saying that at all. He is cautioning with that the proceedings should go on subject to decision by the CAT. That's all.
But
because the decision of the CAT.
After saying this, he's coming back to the old story to say that this should.
No, suspension only the suspension. Suspension period. Let us for a moment assume that there was no suspension. They have a right to give me a charge sheet after my retirement. Who takes away that right?
Correct.
Whether the suspension was there or not, even if the suspension be treated as on duty, they have right to give me a charge sheet. If it is valid in law, it is valid. Not valid in is not valid in law. I cannot question it.
Slowly expanding. He says suspension is duty.
I'm only talking about that period. Because I'll show it from there. There is
we are expanding the scope and he's re-arguing the whole case. Let us have a consensus and travel beyond that. I am ready with your lordship.
Just see paragraph 30 and 14 of their notes. I'll just after that I'll show something else. Only their note of argument.
5 minutes. Complete in 5 minutes.
Yes, 5 minutes.
We can't go on.
No.
In 1986, Honorable Supreme Court said in that famous judgment, Justice O. Chinnappa Reddy, time has come to prescribe the period of argument.
Yes.
We cannot go on deciding these matters like this.
Their notes of argument.
Escorts India Limited, LIC versus Escorts India Limited.
Para 13 and 14.
So we are giving you 5 minutes.
Only 5 minutes. I'll take 5 minutes only and I'll explain within that.
Yeah.
Para 13 and 14 of their written notes of argument. Government. May I read it?
Page 8.
Page 8. As per FR 54B6, where suspension is required pending financial disciplinary or court proceedings, any order passed under Sub-Rule 1 before conclusion against the government servant shall be reviewed on its own motion after conclusion of the proceedings. A conjoint reading of Rule 8.1 and FR 54B6 makes it abundantly clear that when a government servant retires while under suspension, the disciplinary proceedings do not abate. Rather, they seamlessly continue under the framework of the pension rules. The treatment of suspension period, both in terms of financial and its classification, due to otherwise, therefore, must be determined strictly in accordance with FR 54B. What does your lordship have decided about FR 54B? That's annexure R16 of my compilation which I have given only on 7th. There, the proposition, if you have not passed an order in FR 54B1, you cannot pass an order under FR 54B6. That they have not done, and that was my whole argument before the second or before the tribunal. They are accepting that. So this is the law. That's what I'm saying. Beyond that, I'm not saying anything at all. This is my Lord's judgment on 7th.
No, heard, reserved judgment tomorrow.
Lordship.
Oblige your lordship. For a very patient, very patient reason, I'm happy that I could come back.
Today we are not patient. Lordship, patient was also exhausted.
Lordship, it was enlightened behavior appearing before. Lordship.
Item 23, date April 901 of 2025.
Yes, sir.
But 23 is a final hearing. It will take some time. But let me give you, Lordship, briefly what is the case. No, there are three parties to this case. One is the Indian Railways, ECR, East Coast Railways. One is Hindalco, that is my client. And my lord, the third is a company called HIW.
It's a private.
No, it used to be a public sector. Now it has gone defunct. And it by a shareholders transfer agreement, it has gone to my friend's line, who are now representing the top. The case is like this. Sometimes in 1950,
Just a minute. We have exhausted our argument since long. Once it is come, I will not be ready. If they conclude, then I will tomorrow or any next week I will conclude.
Let them start.
Yes. Just give me 10 minutes. Let me tell my lord's party.
Yes. Let them chat. I am clarifying because
so. 10 minutes is we requested him to stay back.
No, that's all right.
We requested. And because some advocate came from Calcutta.
Outside of yes. I know we have almost all we have proceeded last occasion, but again, so let a long gap again.
About 1950 minutes.
Yeah.
The railway line, right from Hirakud to Hirakud, from Sambalpur to Hirakud.
May permission, my lord, just time.
Probably, my lords, that time the Hirakud Dam was being constructed. And there was a company called Industrial Development Corporation. Later it became Industrial Corporation Development of Orissa Limited. My lords, this is a public sector government of the state government. So because the Hirakud Dam was being constructed, this HIW industry also came. Hindustan It is called Hirakud Industrial Works, HIW. My client, company called Hindalco then, Hindal then and Hindalco now. So who is Hindal? Hindal was the largest manufacturer of aluminum in Orissa for a long time, several decades. They employ a large number of people. In fact, Hirakud is now only Hindal. Hindal in course of time became Hindalco. Now there was a railway line from Sambalpur till this plant of Indian Aluminium and beyond. So there was, HIW was using that railway track. And it was, according to the documents we have, at least till 1995 it was going on. The agreement was there from 1995, by which this railway line was being used by Indian Aluminium.
Line was being used means
There was a railway track.
There was
a railway track.
It has gone only to Hindalco.
It has gone beyond. It has gone beyond. So HIW was using that railway track, which is also a public sector. And Indian Aluminium was using that railway line also.
Railway line? Separate wagons?
Yes.
Your own wagon?
Yeah, it is for getting goods in and getting goods out. It was for ferrying goods in and for ferrying goods out. It is called a railway siding. It was a railway siding.
Railway line.
Yeah, that's okay. It's a railway siding. Now, what happened, Willows? This arrangement, first time an agreement was entered into in 2002. This is between HIW, the erstwhile public sector at that time, and Indian Aluminium. Even though, Willows, the arrangement was continuing even before that. And that laid down the commercials, how much you have to pay to HIW, etc., etc. So this is one agreement. Now there is a second agreement, interestingly, entered into on 29/8/2005, 3 years thereafter. But that agreement predates to the time the line was being used. This was between East Coast Railways, HIW, the public sector of IDCOL, and me as a co-user of that line. So I am described in that agreement as a co-user, and on payment of freight, etc., etc., etc. What happens in course of time?
This payment to be made to the railways.
To the railways. Because it is their infrastructure.
Property.
Rather, it's a public sector property built by either HIW and railways together, OS and a small portion by HIW, which was a public sector undertaking at the relevant time.
No. There is a Railways Property Protection of Railway Property Act. Property is defined under that act.
Yes. We will examine
the character of.
We will examine that. So now what happens, Milords? Sometimes in 2006, 2007, this HIW, this industry stops. And from 2007, this HIW has become defunct. 2007. Now,
company.
HIW, which was a public sector company.
It becomes defunct means in company law. What is the meaning of that?
The activities of the company came to an end.
Industrial activities
came to an end. Now, my learned friend, who is now representing HIW, they step in and they have a shareholders agreement with HIW for transfer of shares. Even though the transfer of share agreement, Millards, is way back in 2007, no headway has been made for rehabilitation of HIW. So for all purposes, HIW today is a defunct. Now, I have been using this railway track. They have had their share of problems regarding payment of wages of workers, etc. That's another story. But the admitted position is that I have been using this railway siding as a co-user right since 1995, at least as per the records available. Today, what has happened is, it is the case of the other side, Millards, that I cannot use this railway siding. Because I had an agreement with them in 2002, which I call the commercial agreement. by which they permitted me to use the railway lining, although I was using it wrong time before that, on payment of certain amount of money, which was 40 lakhs per year. Now, what I say is that this was a commercial arrangement between you and me. There is another agreement where railways, you and me have entered into an agreement.
This is bipartite earlier.
And the second one is
tripartite.
In the sense, bipartite agreement between HIW, the then HIW and railways, where I am also a signatory because I am a co-user.
No. Signatory is another thing. Are you a party to that contract?
Yes, my name is written in that contract. It says that I am the co-user of that. And it further says that I will be responsible for all freight, etc., etc.
Some obligations.
Yes, some obligations are there. And these are all admitted positions. But after 2007, in fact, from 1999 onwards, all the bills for dues of the railways are being paid by me. Completely by me. And admittedly also, they are not using it. So what happens means, after this 2002 agreement expires, it was a 20-year agreement. 22 it expired. Now after 22, matters went to NCLT, NCLAT, etc., etc. Railways wrote a letter to me. They said, now your 2002 agreement has gone. What are you doing? I said, matter is pending for NCLAT. You are getting regularly paid by me. I am the only user of that line. There is no second user. By using this track, the track is also being maintained. Structure is maintained. You are getting your revenue. So allow me to continue. Now what happens is the proceedings before NCLAT, they also come to an end. In fact, there's a finding that the whole initiation of the proceeding was fraud, etc. We did not go into that for the moment. My learned friend, HIW in its new avatar, as let's call it, they came to the lordships before the learned single judge. They said the 2002 agreement, by efflux of time, has come to an end after 20 years. There is no further agreement with them.
The tenure of the period is specified.
20 years, the first agreement.
20 years.
20 years. The 20 years has come to an end. It has not been extended. And therefore, you have no right to use the railway track. It was our submission. There is an agreement of 2005, 29/8/2005, and that agreement subsists because the duration of that agreement is still it is terminated. It has not been terminated. So what Railways does is ask me a question. What is your status? I write to them that the matter is pending before NCLAT, A. B, under the 29/8/2005 agreement that is still subsisting, I am paying you regularly. In fact, I have paid them out 40 crores as freight for the time they have not been paying. So allow me to use the railway line, because that is the railway line for my industry. So in the larger public, it's a public property. It is being used. I am the only user. There is no other user. Because HIW admittedly is not using that line. So they allowed me to use that line. Now that is why they came before your lordships. The learned single judge says, Mills, that because the 2002 agreement has expired time, and your right to use that line flowed from that agreement no more being in subsistence, you have no right. You have no. In short,
what the second, that 2005 agreement?
The 2005 agreement is very interesting.
Right.
Even though it is executed in the year 2005, it says it will predate to the time from which this line is being used. Line is being made.
You're assuming, is there any prohibition for entering in the Contract Act?
Yes, sir.
Is there any prohibition to have a contractual arrangement with retrospective effect? Although generally retrospectivity, the great authors like C.K. Allen in The Law in the Making writes, retrospectivity is an attribute of the sovereign. But is there any prohibition in the law of contract?
Well, that we will examine. That we will examine in assist your lordship. So in net, my lord, this is the case. And very interestingly, my lord, that second agreement, which was executed between the parties,
Can you take one clause from 2005 agreement.
Yes,
Which recognizes your right.
I am grateful to you. Straight away come to.
15B.
My lords may kindly see minutes. The 2005 agreement starts from Annexure 2, Annexure 4 minutes, page 91. Please sit down. Proper things. If my lords are kindly pleased to, let's come to page 102. My lords have page 102 minutes.
Yes.
There's a clause called 15.
Siding not to be used by other
Persons. Kindly see 15B. The applicant.
What is meant by siding?
Siding is the railway siding, because the railway siding is
Where
the place
the materials are being
materials go
uploaded.
for loading and unloading.
This is right. Yes. Siding not to be used by other parties.
Yes. Now kindly see 15B. No exception has been carved out for me.
Now let us read 15.
Let us read. No traffic, inward or outward, other than the applicant's works. Applicant may not be the HIW at that time. Shall at any time be sent over the siding of the applicant, except with the prior permission of the railway administration, and the applicant undertakes not to permit any other person whomsoever to the railway siding
to use the siding
and not to take or receive, permit any other person to
occupy,
to take or receive from any other person whomsoever any consideration or remuneration of any sort or in respect of carrying of commodity over for any purpose whatsoever in connection with the siding, except with the written permission of the railway administration. And in all cases of disputes and differences with regard to any matters mentioned in this clause, the decision of the Chief Operating Manager, Chief Commercial Manager, East Coast Railway shall be the final and binding on the applicant. Two things, friends. So you cannot give it to anybody else. If anybody has to use, then there has to be a prior approval of the railways. Kindly see 15B. The applicant is forbidden to assign, transfer or sublet in any manner whatsoever either whole or any part of the siding without prior written permission of the railway administration. The booking and delivery of the traffic, this line is important, kindly note it. The booking and delivery of the traffic of co-user of the siding, of the co-user. So here they introduce a concept of
whether you are described as co-user.
Yes, I will come there. I'll just come 3 days about. Co-user of the siding shall be governed by the same rules and regulations as applicable to the siding owner as far as levy of freight and other charges are concerned. The siding owner shall give a written undertaking that Hindalco Industries, that is me, has been allowed to use HIW siding, name of the siding owned by him with his consent, and that the co-users will be responsible for the payment of all railway dues that may accrue as a result of granting of such facility. So this is where I come in. So 15 says is that you as the co-user will be obligated to pay all the railway dues to the railways, and HIW will recognize that. May read it again, 15B.
Yeah.
The applicant is forbidden, applicant means HIW, is forbidden to assign, transfer or sublet in any manner whatsoever either the whole or any part of the siding without the prior written permission of the railway administration. So therefore, the precondition of anybody allowing to permit to use that lies with the railway's permission. The booking and delivery of the traffic, not here co-user is now introduced. Booking of traffic of the co-user of the siding shall be governed by the same rules and regulations as applicable to the siding owner as far as levy of freight and other charges are concerned. So whatever HIW was supposed to pay, you will be liable to pay the said charges. Who? The co-user. The siding owners shall give a written undertaking that, not here I come in, that Hindalco Industries Hirakud, name of the party co-user, has been allowed to use the HIW siding, name of the siding, owned by him with his consent, and the co-users will be responsible for the payment of railway dues that may accrue as a result of granting of such facility. So this is where I come in. Now, if your lordship sees two more clauses.
Can we see the meaning of siding anywhere? Meaning
Yes,
of
sir.
siding is given.
Yes. If your lordship kindly sees, Millards, page 93, paragraph H.
Siding includes.
Siding includes the railway track connecting the applicant's works with East Coast Railway System as hereinafter agreed to be constructed by the Railway Administration and all branches and extensions thereof, which may be hereafter be construed by the applicant.
Constructed by the.
Your lordship may not give much emphasis to that because this has already been constructed since 1950.
Is it?
Yes, I'll show that, your lordship, in a minute.
No, but why they are using
These are all
verbs?
These are all printed formats. These are all printed. I'll make it good. Siding includes the railway track connecting the applicant works with the East Coast Railway System as hereinafter agreed to be constructed by the Railway Administration and all branches and extension thereof, which may be hereafter be constructed by the applicant or by the Railway Administration, and the applicant's request and all sleepers, ballasts, embankments, bridges, tunnels, signals, interlocking and telecommunication equipments, gates and buildings and other constructions, erection works and movable property constructed, erected, made, provided or used in connection with the said track, and also of all land whereon part thereof the said track and connected things aforesaid are constructed, erected, made, provided, including land for the purpose thereof, as hereinafter provided, and land belonging to the Railway Administration and the land belonging to or occupied by the applicant. Now, who is the applicant? Who is the
sentence? Somewhere something is missing.
And your lordship will see, Millards, works is defined in page 92. F.
No, kindly read it again.
Your siding? Yes, I read it slowly. Siding includes the railway track connecting the applicant's works with the railway system as hereinafter agreed to be constructed by the Railway Administration and all branches and extensions thereof, which may hereafter
be constructed
by the applicant or by the Railway Administration.
At the
applicant's request, and all sleepers, ballasts, embankments, bridges, tunnels, signals, interlocking and telecommunication.
XYZ.
Yes.
Then how sentence ends? There is no verb.
Yes. Yes.
How to construe this?
All that railway siding says is the entire infrastructure from railway line to the railway siding, whichever is required for the wagons to come, discharge, take in and go back. So that becomes
the property of the railway.
That becomes the property. I'm grateful. That becomes a railway property. Now, while your lordships are here, why I said this agreement is for a prior point of time, kindly just come to page 77. We come there. If your lordship sees page 77, annexure 2 minutes.
This is alphabetical list of railway stations.
Yes, just kindly see covering page is 77. And it is corrected up to 31st of March 1995 at the foot of the page. Now, my lords may kindly turn over the page. In alphabetical order, your lordships will find Hirakud Industrial Works, siding of Industrial Development Corporation of Orissa, HIW. My lordships have it, my lords. Now, kindly come to the extreme right. It says Indian Aluminium Company Limited, that is me, Hirakud and the Aluminium Industries Limited, Hirakud, have been permitted to use this siding for outward
and
inward
goods
traffic in wagon basis. So therefore, my lords, by 1994, this definitely as on 1995, this infrastructure was
readily available.
Was existing. Now, while your lordships are at 93, just see two more clauses, my lords. If you kindly please to come to minutes, page 111. Even though this agreement is dated minutes 2005, and to be exact minutes, it is 28th of September 2005. When my lord sees page 111, kindly see paragraph 36.
From the date of opening of siding.
So definitely this siding agreement, this agreement predates the 2002 agreement. That's the submission. This agreement, my lords, predates the 2002. And if your lordship sees one more page, my lords, there is an IA at flag. There is an IA called flag 4739 is an IA.
Yes.
And my lords, and let me tell you, lordship, this document was not before the learned single judge. Flag E.
Now, with leave of the court, you want to produce.
Your lordships have a look at it. It says, page 12.
Paragraph you may say, since it is not paginated here.
Yes, all that it says is, minutes, that Hiroku, it is an annexure to that document, to that IA. It is an annexure to IA 4739. And it is page 12, the last page of that document, minutes.
You're right.
It says HIW, serial number 31, and kindly look at the right. It says 31st of March 1950. All that trying to, these are all details of private signing of East Coast Railways, Annexure 1.
Date of commission.
It says
Date of commission.
details of sidings. My lords have it, notes. Page 11, Annexure 1.
Annexure 1, serial number.
It is the private siding over.
And you see the columns, name of the siding,
Yes.
address, and date of commission. And if my lords kindly turns over the page, minutes, page 12.
In other words, all this infrastructure was already available.
In 1950, it says serial number 31, Hirakud Industrial Works Limited, Sambalpur, 31st March 1950.
But why that clause which you have read now?
Yes.
It speaks of future executory obligations.
Because this is a printed form. And the lordship may see, 36 therefore says that this agreement shall be deemed to have come into force from the date of opening of the siding. The siding was opened sometimes the siding place sometimes in 1950 and definitely there since 1995. And this agreement also says, minutes.
But who are the signatories to the agreement?
To the 1995 agreement? I am grateful.
2005 agreement.
Yes. Your lordship may kindly come to minutes. Page 112.
2005.
Kindly come to 112 minutes. Let me answer your lordship's question straight away.
Whether all high functionaries have signed it or...
Kindly see minutes. In witness thereof, page 112. Signed and sealed and for and on behalf of the President by H.K. Datta, Deputy Commercial so and so, minutes, P&E.
No, from your side?
From my side, my lords, in the presence of K. Rai, Senior Manager level of Hindalco Hirakud.
See, this is not an agreement for 3 bigha land between two farmers. This is very high functionaries.
Your lordship may be right, minutes.
Having abundant English knowledge, men, matter, commerce, they have entered into this agreement. As to the interpretation of such clauses, which Chicky on contract mentions.
Yes.
Will be different. Only when commoners enter into obligations. This is how Chicky uses the word.
One has to see whether how is this person authorized and all that.
Where very educated people.
Yes, ma'am.
And men having high standing conclude agreements, then ordinarily the clauses should be interpreted keeping in view Wren and Martin English grammar. There is such a decision also. I don't remember which some English judge said like that. Otherwise, you will be asking us to rewrite the agreement, which court cannot do.
But not the 2005 agreement. 2005 agreement is sacrosanct. I don't have to touch it. Because 2005 agreement also says, how the agreement is to be altered, how it has to be varied, all those things are there. The learned single judge said, this bipartite agreement of 2002 ended in 2022 after 20 years. According to me, it was a commercial agreement. What will be the rates for doing this activity? For using the line, what you will pay me? And after 20 years, that will be revised. So by 22 came, HIW had become defunct. Their workers were not paid, the railways was not being paid. And kindly look at it from a point of equity minutes. Here, 10,000, 50,000 people are working. HIW, my learned friend's client, doesn't have any utility of that line. He says, look, your 2002 agreement has lapsed, so till I permit you, you can't get it. Am I clear, my lords? They say that I don't need the line, I can't use the line, but if you use the line, you don't have my permission.
So is it 2005 agreement or the earlier agreement?
He is there line.
Has given the privatization of the siding to HIW. Well,
HIW had the citations from the earlier point.
1950.
50. When they came later, the siding was there in 50.
Siding was in 50.
Definitely in 1995, HIW was using it. That your lordship saw on that page.
Using it. As a private siding, that is how he is giving you the right.
HIW was a public sector company, as your lordship knows. It was an ITCOL company.
Yes.
So HIW was using
it. Is a state.
ITCOL is a state. ITCOL is a state. So therefore I say this is a public asset created either from the money of the railways and partly of money of HIW. Either way means. And this railway siding was always there. And as it fell from my lords, these are all railway assets. The document, the agreement also says so. I am giving you this railway siding for use. You can't give it to anybody else for use.
That is why permission is required.
And if you want, you take my prior permission. If it was HIW siding, railway had nothing to say about that. And it said it recognized me as a co-user because I was using at that point of time and said, look, you co-use, but you have to pay. So therefore, my lords, it's an asset made by the railways and it was being used by ITCOL. I was recognized as a co-user at least since 1995. The 2005 agreement predates the date from which this railway siding is being used. 2002, according to me, is a commercial arrangement between the parties, namely what money I will pay HIW. And that commercial agreement having not been thereafter extended because HIW went defunct. 2007, they stopped. Then there were a lot of litigations. Workers were not paid. They have not been paid till now. Nothing is happening in that company. And today they are saying, they told the single judge says, look, your 2002 agreement has gone. So therefore you are out. But what happens to my 2005 agreement? In short, that is our case. And the lordship may post it to 5th or something, we'll come and finish it.
How many?
Whatever.
What was that? You said morning 10 matters are posted plus 1 matter is posted. 5th, 11 matters. How many? Just looking. How many matters? Tomorrow's 5th of May.
5th of May, 11 matters.
11.
7th minutes. In fact, I also have 1 matter on 5th.
Seventh, still okay with the benefit.
Seventh, my lords, have some prior commitments. If it could be sixth, if it is convenient to your lordship.
Sixth, I'm in a little difficulty.
Another date. 11th?
11th, please, man.
11th is a Monday, minutes, I have Supreme Court. 12. Yes.
Concluded. Learned, not sitting here, it was paid. For first time. At the request of both the sides. For this case on 12th of May, 2026. For further
If your lordship says 2 p.m., you'll not given. Grateful with. But the interim order to continue.
Interim order.
Grateful. We met yesterday, minutes. I said I joined the bar in 1984. He said I was born in 1984.
No,
I went to school in
I
1984.
joined the school in 1980.
Yes.
Did you oblige?
Item 24. Rate appeal 1359 of 2025.
Millards, in item 24, Millards, with your lordship's leave, I beg to appear virtually, Millards. In item 20. Millards, I have filed today, Millards, my rejoinder to all the opposite parties. There are 4 rejoinders in total. That, Millards, I have filed today, and I have also served on my respective learned friends, Millards. So your lordship's...
Lord, I appear for opposite party 8, my lord, the contesting private party, my lord. My friend had taken 3 adjournments. Now he says, my lord, he is now served the rejoinder copy today. We haven't been served, my lord, but be that as it may, my lord, he should have at least given it yesterday so that we argue the matter, my lord.
You have your copy now?
Yes, sir.
Copy.
Yes, now if he's giving my lord, please look at the last 3 orders, my lord. He has taken time twice, my lord, to file a rejoinder. 3 times.
I have filed it, Millards, today. I have
It's a
filed it.
deliberate ploy to delay the matter, my lord. My lord,
I'm sorry,
please submit, my lord, if I could just, your lordship, my lord, please have it on the 1st, my lord. I'll come there and argue physically, my lord, on 1st.
1st of May.
Yes, my lord.
It's a Friday. Generally, we both myself and my brother dissociate.
Oh, I see. I see.
Choose some other date.
Lord, then can I have it on the 14th, my lord? 14th of May?
On 14th?
Yes, my lord.
All right. 14th, all right.
Millards, I was requesting 1 day prior on 13th, if possible, to Mr. Mehta.
I have some difficulty. That's why, my lord, I requested for 14th. My lord. If my learned friend can accommodate me now.
You start on 14th.
Very well.
Pleadings are complete. Copies are shared with each other. At the request of the bar, call on 14/5.
Millards, the rejoinder, Millards.
Small notes that day. Very short note.
My lords.
So that it will put us in the focus.
Yes,
My
my
lord.
lord. We'll also prepare one, my lord.
Right. Millards, the rejoinder, Millards, we'll file it in the registry, Millards, or we'll hand it over across.
It will be handed over here.
It is there.
Yes.
What?
The
Is
rejoinder.
it a small note?
No, yeah, this is a rejoinder.
That is filed in the office. We don't know whether it is in format or not. All the registry will look into.
Lord, may I request that it could be high up on the board, my lord? It's a humble request.
Or subject to my lord's board, could it be at 2 p.m. also? That will also help Mr. Mehta in...
On 14th of May.
No matters.
No matters. No matters are posted, but we do not know. We may post other matters also. We'll let it be there. In the event we pass it over, you come and argue it too. All right.
Lordship, please.
My lords, grateful.
Obliged.
Yeah.
Item 25. WPC 8933 of 2025.
Item 25, your says. In this case, the subject tribunal under challenge is of the date 28/8/2024. Subsequently, my learned senior on the last occasion handed over me to one order of learned tribunal, which has already been implemented. For that reason, I also took time to take instructions from the department whether such an order has been implemented by the department, because the similar nature of prayer has been made.
Your Lordship, they have already allowed them under the old pension scheme. And that was also the grievance of the petitioner before the tribunal.
So nothing survives.
Nothing survives, Your
Your
Lordship.
appeal, your petition it is.
Why am the petitioner, my lord? I am the opposite party here. They have challenged.
Judgment also handed over to my lord. If I have extra copies, if can be on the last portion of the order, because the post was created in 2015. That's why, but he's working since 84, so he can be availed with the old pension scheme because it has been already extended to the other similarly placed persons.
With that observation, we can dispose of.
Lordship, blessed.
That order has been implemented.
Yes, this order has been implemented, Your Honor.
Last.
Last page, my lord, page 8.
The identical matter it is.
Identical.
Smile.
Subject matter. Union government.
Yes.
Your Lordship.
Go to the cost.
Petitioner is the Durdarshan.
Yeah.
Sarvaj.
The union government and its Prasar Bharati is a corporation.
Your Lordship.
And its entities are knocking at the doors of each court for sealing the Cuttack Central Administrative Tribunal's order dated
28/8/2020.
28/8/24, whereby OP employees OA number 561 of 2018 having been favored, relief has been accorded to him, while there are 8 thereof, which has the following text. Right.
Page 7.
Para 7 and 8.
7 and 8.
Para 7. There it's phase 144 and 145. Next paragraph. Learned counsel appearing for the, we'll say they have produced it instead of using.
Actually, they have produced. I have
Produced it.
Yes, last of is my letter.
Employee who was the applicant before the tribunal tells us that a similar order made by the tribunal in OA number 260 129 and
18 and 725.
in OA numbers 216 need not be 129 of 2018 and 725 of 2019 between Janaki Prasad Mohapatra versus UOI and others has already been implemented by the petitioners herein, by the order number. This is last page.
Yes, my lord.
Number. Yeah. Dated the 12/2025, and therefore, as a matter of verity, this petition should be turned down with a direction to implement the impugned order of the tribunal. First, learned senior panel counsel appeared petitioners, the next paragraph, on being confronted with the order of the Prasar Bharati aforesaid order of the Prasara Bharati dated 10/12/2025 very fairly does not dispute the position. First of all, Prasara Bharati being a central government entity has to conduct itself as a model employer in the light of Apex Court decision in Bhupendra Nath Hazarika versus State of Assam, 2013, and therefore cannot discriminate against the OP employee who also constitutes a part of one homogeneous class of other employees similarly circumstanced. First of all, next paragraph. In the above circumstances, we decline indulgence in the matter and thus the petition fails. Coupled with a direction to implement impugned order of the tribunal, as has been done in the case of in other similar cases, within an outer limit of 8 weeks. 8 weeks. Without driving the OP employee to take proceedings. No cost. 26 is the time. That will not is 26 reserved tomorrow, sir. Okay. All right. Take 1 or 2 minutes. Let us see.
With list item 1, need appeal 444 of 2024.
Passover. Next.
With list item 2, need appeal 460 of 2025.
Yes. Which is the oldest matter in the list? Why oldest matter is not above the, why the seniority is not maintained in preparing the list?
Doesn't matter come first, it will be first.
No. It should be on the seniority. Now, since the guidelines of the Apex Court registry, all High Court should follow seniority in preparing the list. Right? In these matters, notices have been not. Okay. All right. Yes, brother.
Your Lord, the issue is.
So they are in admission list. But other 24 matters, they are not admission.
So which one?
Serial number 24, that there are some matters which are
24.
So all are fresh.
All fresh matters. But then why they are not in seniority?
How does it matter even if it's sorted?
If they are for admission, they should be depending upon their seniority. From tomorrow, it should be that way. All right. And principle, if list is prepared otherwise, you will be answerable. Yes. Serial number 2. Yes, brother. What is this matter about?
Here is matter. Here the issue is, my lord, whether the area dues can be denied on the ground that there is a conviction in vigilance case, though the area dues is pertaining to the before
pre-conviction period,
prior to institution of the vigilance case
proceedings.
Yes, that is the short question to me.
How courts have treated that question?
That, my lord, annexal 1, my lord, impugned judgment, my lord. Come to page 11, my lord, that is para 5, concluding para. Having heard Lord Counsel appearing for the, my lord, come to.
Yes, I read.
My lord, para 5.
Been convicted and the vigilance proceedings so initiated with regard to the misappropriation, this court is not inclined to interfere with the impugned order. Reinstate his claim if he is ultimately acquitted. What is the punishment, conviction and sentence? What is the sentence?
Sentence is, my lord. My lord,
any fine is imposed?
Yes, ma'am.
How much money?
Exactly, my lord, they have to. That, my lord, sentence was passed, my lord. Fine of rupees, 2 years imprisonment, array of 2 years,
And fine?
1,000 fine.
1,000 fine. And default of fine?
In default of fine, array of 1 month.
1 month. You take notice. Let us see. Mr. Panda, you accept notice.
Well, the reasoning, para 5 and para 5.1 of the judgment, your lordship, kindly have a look thereafter, lords.
Yes.
Page 11, running page 11, para 5. Having heard Lord Counsel appearing for the parties and considering the submission, it is found that the petition was provided with the fund for construction of the school building in the year 2008-9. Even though the petitioner completed the construction up to the plinth level, but the work was never completed, nor the balance amount was returned, in spite of several requests being made. Petitioner in the meantime also absconded with effect from July 2011. Considering the fact that the petitioner has now been convicted in the vigilance case to initiate the, with regard to the misappropriation, this court is not inclined to interfere with the impugned order. It is open for the petitioner to reiterate his claim with his, he is ultimately acquitted by the court in criminal appeal number, so that's a pending criminal appeal.
No. Which law gives you power to withhold the money payable, otherwise payable to him on the ground that he is convicted?
That to prior to institution of the.
This is much before initiation of the criminal proceeding.
July.
Subsequently, he has been convicted, all right.
Cognizance part is there.
How?
In fact, my lord, the
initiation itself is subsequent. You accept notice.
Rule 60.
Two high courts have held against your argument.
Rule 66 of the pension rules.
Sorry. 66, 1992 pension rules. That provides for withholding of pension.
He only provisional pension.
Correct.
Yes.
But this has nothing to do with the pension. This is the amount due, which earned earlier, prior to the initiation of the proceeding.
Amount due means what?
For example, suppose
so cause of action not aroused.
Initiation itself was not there. Suppose I earn my salary, he earns his salary. For 1 year, you are not paid the salary. And thereafter.
So it will not be treated as terminal benefit. It is not terminal. It is
Something other than terminal benefit. The rule, that rule relates to terminal benefits.
Terminal benefits.
You just take notice and
yes,
issue emergent notice. Learned AG Mr. Panda on the request accepts notice for all the votees. First. Next. I better leave next pass. Post it in the last week of May. Yes.
Item 3.
Last week of
May. The holiday, my lord.
The 3rd week of May.
Item 3. Read Appeal 614 of 2025.
It's in this matter. I'm challenging the.
Came running. Sit down for 5 minutes. Hello, yield your place to the next person in the row. Yes. Next.
Item
number
4. Item 4.
4.
Read Appeal 1147 2025.
5.
Item 5. Read Appeal 1520 2025.
My pleasure. Sorry,
My file is not there.
My lord, item 5 and item 6 are same.
5, 6 are same.
Yes.
It appears he does not have the file. All right. 7.
No, sir. My lord, I am here for item 6. I want to present my submission, my lord.
But 5, 6 are same.
5, 6, I don't think that. So I want to present my submission, my lord.
All right.
My lord, this is a writ of, and I want to present before you 3 aspects of this appeal. First is that, my lord, the impugned dismissal order, which I have challenged here, is based on
misapplication of ratio decided. And second is, my lord, the essentiality and urgency of that interim order on the basis of heightened legitimate expectation. And third is, with due apology, I want to say that the judgments which have been made ratio here are made mockery because by presenting so
where the selection commission's advertisement is dated 2/11/2022.
Yes, my lord.
You take us there.
So I want to explain, my lord.
Let us
Take us to 2/1/22. 2/11/22.
Page 18, my lord.
Show that. How that.
Page 18.
One can criticize the judgment in any way you want, though you cannot criticize the judge.
No, sir. No, my lord.
We are agreeing with you.
Judge, I have not criticized.
We are agreeing with you. Therefore, we say, though it is a bitter criticism of the judgment, it is permissible. We can criticize the judgment. Unless, but that goes to the level of the judge himself.
My lord, I have told that with due apology, my lord.
No problem, no problem. We understand that. We made a law clear, that's all.
Yes, my lord, the judgment is contended with due.
You are all, you are a big engineering graduate.
Yes, my lord. I am engineering graduate. And as per 2022 advertisement is at Annex 3, page 30, my lord.
Why you went to the learned single judge?
Because I was not aggrieved by the judgment, advertisement 22, because the general eligibility criteria was, so far as educational qualification is concerned, minimum diploma. Minimum qualification is diploma. So I am a graduate. So I do have the maximum qualification. And in the same line, so when I wanted to...
Mr. Panda, covered by the apex court judgment. It is.
My lords, this is relied on by division bench judgment.
But now learned single judge denied relief to him.
My lords,
the
requirement is diploma, my lord.
Not a disability. Higher qualification is not a disability.
My lord, this is like this. Suppose somebody has diploma degree, then degree, is qualified. That is the judgment.
Suppose required degree is MBBS. There is a person who has done his MD or MS or master of...
He has undergone MBBS first, then... But here is the thing is different. And another judgment in my lord's...
when you say diploma in civil engineering, we are giving an example. Diploma in civil engineering graduate can apply. You mean to say the graduates in civil engineering cannot apply?
That is the judgment.
Latest judgment of the apex court.
Yes, my lord. There is judgment that higher qualification is the same line.
We told that one only. Give that copy.
So I am giving, my lord.
Two, 3 months ago it came.
But he includes, bachelor in engineering includes diploma.
My lord, you understand, but this, in this appeal, the division bench has dealt like that, my lord.
Similar division bench said
my lord.
Bihar, that is overturned by the apex court.
Page 154.
My lord, Jyoti KK versus Kerala Public Service Commission, where it has been written.
Which is that citation?
Sir, yes, my lord, 16 SCO 2021.
16?
2021. 16 SCO 830.
Yes.
SCO. Do you have copy of the judgment with you?
No, my lord, I have referred, but I can give the copy.
Then next week, again, one more adjournment.
No, my lord, I have not brought that because it has been recited.
Okay. Where is it?
See, kindly read para 6. The commission contended before the High Court, as is done before us now, that the graduates in engineering or persons possessing other qualification as held by the appellants may not be taken as higher qualifications. They are not equivalent qualifications prepared for the post person so and so, so and so. On the question that the said rules are applicable, fine. However, we must notice one aspect of the diploma holders who had been selected by the Public Service Commission have already been appointed, and therefore it would not be appropriate for us to disturb those appointments. They shall continue in such of those eligible degree holders who fulfill the qualifications referred to above are found suitable to be appointed shall be appointed, taking note of the vacancy. Identical question is answered against you. There the engineering graduates were kept out, saying that our prescription is diploma.
Right.
The Apex Court said no. But the Apex Court did not disturb the appointees because already appointments had been done.
My lord, in the division bench judgment.
Which year?
This
21.
25 money.
25. Has it considered this aspect of the matter?
Yes.
This judgment is taken note of.
No, my lord, I want to.
1 second. We are asking.
Okay, my lord.
How will you
Sorry,
know what
sorry.
he has-
Sorry, my lord.
My lords, here,
Latest judgment.
21.
Chandrasekhar Singh and others versus the state of Jharkhand. 25 live law. Supreme Court
2025.
live law, Supreme Court 336.
336. Take out that judgment. So Chandrasekhar?
So Chandrasekhar Singh and others versus the state of Jharkhand. And
Chandrasekhar Singh and others of the state of Jharkhand. Take out that. Citation. This is the judgment. Mr. Behura,
My lord.
first time it has come.
Yes.
If we allow that, immediately we will file SLP on that we have not been given.
No, my lords,
We take notice.
Staff Selection Commission.
Commission notice has to go.
My lord, most important is that for which I am standing here is essentiality of giving interim relief to me. Because
What interim relief?
Relief means I should be given appointment because I was.
No, that cannot be.
No, listen, please listen, my
We
lord.
will listen you.
So,
But interim relief and final relief cannot be same.
My lord, this is a case within a case which has become, and whatever may be the decision, whatever may be the decision, this interim relief must be merged in the.
Is for OP number 2.
Relief cannot be in the interim.
Who appears for
My lord,
OP number?
my lord, listen, please listen.
All right, it is nothing more. It's an admission.
So
stage.
I have already been selected, my lord.
The interim relief.
My lord, I have been.
Clear for interim relief will be considered on the next date of hearing. Got it. All right. Who appears for the staff selection
My lords,
commission?
Mr. S.N. Patnaik. your lord.
SN Patnaik, the panel council is requested to accept notice for OP number 2. Appellant to serve copy of the petition appeal memo along with all the documents on the said panel council. Call in the third week of May 2026.
No, my lord, it will be too late. My lord, please. My lord.
Next.
Item 7.
Item 5 and 6 same होगा.
5 and 6. No.
5 and 6 same.
This is 6 also, 5 also same ordinance.
Pass over item 3.
You give half of your fee to him. He has argued your case. Yes.
Item 3, Heat Appeal 614 of
Along with each other.
Item 3.
relates to removal from service, my lords. The learned single judge interfered the order of punishment with regard to recovery of
78.42
lakhs. But I refused to interfere with the punishment, my lords. Refused to interfere with the
punishment of removal from service, my lord. And the bank has also filed being partly by interference of the single judge with the recovery part. The bank has also preferred an writ appeal, my lords.
They have preferred.
Yeah, my lords.
That in that notices are issued.
No, my lords, the notice.
Call this matter along with the writ appeal number
606 of 2025.
in the second week of May. Okay. Next.
Item 7. Writ appeal 1708 of 2025. Item 8. Writ appeal 1831 of 2025.
Wait, please. My lord, the subject matter is horizontal reservation.
Horizontal reservation.
My lord. And the of home guards. Now, the issue before this honorable court is the accepted version is the accepted and undisputed fact is these selections are made first on merit, then they are fitted into their respective categories. My lords know it. The issue came after the selection was made. 3 didn't join. Now they were home guard, SCVC. The direction came. I was appointed. I was dismissed. I was not made party. So earlier background are many, but finally that court directed to appoint me against the non-joining vacancy, affirmed by this honorable court. Now comes the rejection order that since the vacancy was home guard SCVC and I am UR, I cannot be appointed. The issue before this honorable court is, I raised that home guard, my lords know, that home guard being a special category, they are selected on the basis of merit, then they're fitted into the respective categories. So it's a home guard vacancy, not a home guard SCVC vacancy. That's that in 2 lines, if I can sum up my case like this, man. If, my lord, 44 posts were kept for home guards. Total 48 candidates were selected. Out of the 48, on merit, 44 persons were initially selected. Out of that 44, 3 persons didn't join. Now those 3 persons were SCVC candidates. I was at serial number 45.
Your general merit.
I am general. Now, if there is a direction that to appoint me against the non-general vacancy and the department came up and said there is no vacancy, will they be correct? When the home guard vacancy is not category wise,
take notice.
That is a simple, and I am supported by the decision, my lords. Since the original vacancy is not category wise, the subsequent vacancy cannot be turned to be a category vacancy.
Learned issue emergent notice. Learned AGA, Mr. Behura, on request accepts notice for all the response. Matter lies in a narrow compass. Call it in the 3rd week of May 2026. In the meantime,
only on the point of law I will address this honorable. Blessed.
One more.
Item 9. Writ appeal 1878 of 2025.
Yeah.
Item 10. Writ appeal 249 of 2024.
26 stated the appellant and the respondent matter. This is the petition matter covered in the Bhagavatamadi case. This petition was a retired person.
My lords, in view of the recent judgment of Maharashtra case, this person doesn't have teacher's training qualification. OTT. So it requires consideration.
Requires for notes, my lord. Matter already, Bhagavatamadi case is applied in the Honorable Supreme Court, my lord. Also, other division bench, coordinate bench, my lord. That's of that decision.
What is the point involved?
This petition,
my lord,
in 23.
This person doesn't have teacher's training certificate.
How many years of service he has put in?
Well, it's a lot of number of cases are there. The Lordship may fix to another date.
Yes.
So that I'll have to-
Madam, how many solution man this person retired person?
No, salary.
Madam, kind of.
He is retired.
Madam, since 23. I'm supplying.
After retirement, what you want to do to him?
My lord, then what he wants now?
Even they are not getting gratuity also. They are suffering very much. 6,000 salary.
What the single judge has said?
Single says the annexed to my document, madam.
They were covered by Dramaji case numbers.
Minimum pension. Minimum pension. It's
Well,
covered.
sir, I'll examine and your lordship may fix to.
How many days of delay?
51 days per month. 51 days. 441 days.
19 days, 419 days.
How much it will be? At the age of, if it is 420, it would be 8,400. Okay. 8,380 you have to pay. If you agree to that, then we can.
My lord's it requests because a number of cases are there.
You take that 8,000 odd money first for condonation of lease. This appeal against the order of a lieutenant single judge has been moved after booking a long delay of 419 days. First of an application supported by affidavit accompanies the appeal memo. First of some explanation is offered which is not that satisfactory. First of however, there is a which merits due consideration at the hands of this court, and therefore, at the threshold, if the appeal is rejected, that would be causing a great injustice to the state which is in appeal. First off, some equity has to be worked out while condoning the delay, which we do by awarding some costs to the respondent employee. First off, in the above circumstances, application having been favored, delay is condoned, subject to the appellants collectively paying a sum of rupees 8,400, which amount is computed by taking rupees 20 as the levy for each day's delay within 2 weeks. 2 weeks, failing which
3 weeks.
within 3 weeks, failing which the application stands rejected, and as a consequence, appeal to first off, call this matter immediately after 3 weeks for possible dismissal. Okay. Let us see, even if we write, he will not let us go. The respond, payment to the respondent. Okay, not report.
Record.